8:50. Yeah, we're 10 minutes early, actually.
Yeah.
I don't know about that.
Honestly, I think with the badges, though, they should definitely have them for bar licenses.
Yeah.
I don't know why they don't.
I feel like they should have our bar.
All right. Edward should be on his way.
Okay.
And Miss Killmer's already here.
Nice.
What's happening is that basically we're digging each other just
How's it
like
going,
someone
Gary?
who recently got a breakup with a ton of action and shit.
Hello? Okay.
Hello.
Did you hear me?
Hey, what's up?
Hey, what's going on?
Those are your arresting officers right there behind you, confronting Judge McGowan prior to trial. I think if any good defense attorney would absolutely file for a mistrial, as why the fuck are they able to sit there and talk with the judge prior to the trial?
Well, I mean, do you know what the contents of their conversation are?
Communist.
Either way, they're not allowed to be talking.
Communist.
I mean, just something you can bring up, you know.
Yeah.
I don't even know what it's. Well, the arresting officer was what's his face? Fucking Nicholas Thompson. I don't even know what he looks like, to be honest.
Oh, it's Thompson?
Yeah.
So that, they're trying to set up all the other
It was Nicholas
places, bro.
Thompson. The other ones were the nose on those guys, but they were told. We were told by the court that they weren't available for trial. So.
Shit.
Really?
I mean, that's why you initially requested written statements from them, right?
At least, bro. At least.
Why is everyone
I was
shouting?
getting written statements for them, so maybe they didn't have to show up. You know what I mean?
Oh yeah, I'm cool.
Yeah.
I wanted to see what they had to provide.
Yeah.
Shit, wait.
I'm honestly not worried about it. The state had. I mean, the state had very paper thin circumstantial evidence at best. If anything, the PC for Dahmer is getting thrown out. That's my plan, at least. I'm motioning for dismissal on his charges out of the gate. So.
I ain't fuck with God.
Yeah, they're gonna fight that, obviously.
Oh, I know, but it's gonna set a tone. The evidence that they have on Dahmer is that the officer recognized him. Okay, he was wearing a full helmet and mask. So how did you recognize anyone?
Okay.
So if Dahmer's testimony is that he recognized his voice, well, guess what? That's not PC, and that gets thrown out. So
I'm interested to see. Isn't around right now, so
yeah. So I think we'll be right. I gotta go meet with my client up there real quick.
She's right over there.
Yeah. But no, I appreciate you stopping by. We'll see how this goes. I'm looking forward to it.
Good luck, Evan.
So where are they and shit?
Why is everyone yelling?
I don't even really
Kitty?
know how to check my email. Oh, my fault.
Have we met?
Oh no, I'm sorry. Where's Kitty? Oh, there she is.
Do I look like her? Or do we just talk
No, it's just it's hair color. I'm sorry.
Ramsey.
How's it going, Travis?
I fuck your
Hey,
bitch
Kitty,
like
how's it
I'm
going?
Ray J.
Good, how are you?
Dude,
Doing all right. How do you
fucking it
feel?
up like I'm Ray J.
Great,
Fucking your bitch like
fantastic.
Ray J.
I'm telling you what, the kitty is borrowing this
someone write
jacket
that down.
from the
No,
department store.
Okay.
Cooking it up like I'm
Just
Ramsey.
hide the tags, no telling anyone.
Ramsey.
Yeah,
I fuck
for
your
sure.
bitch like I'm
The
Ray
tags are
J.
gone.
Cause the Ray J Kim K sex tape.
Oh yeah.
Yeah. So the I'll make my opening just so you haven't. I don't think you've been in court before, but I'm gonna make my opening statement. The prosecution will make their opening statement, and the prosecution will start calling witnesses. I'm sure they'll call Nicholas Thompson, the primary arresting officer, up first. His dealings are primarily with Edward's situation.
Breaking the neck, what you do in the
and
name.
then we'll see if they have any written statements regarding your situation, because I don't think the arresting officers for you are here.
Okay, great. That's so funny. What a funny joke. Okay.
This has been interesting.
Yeah, so if your arresting officers aren't here, then they basically are going to have to rely on the report. And that way, if all they have is a report, then putting you on the stand will actually work out in your favor, because there'll be no one to refute your statements.
Oh,
Okay, awesome. Yeah, for sure.
On my knees,
So we'll
like
see.
I'm about to pray.
I mean, I think, like we
But
said,
it's a
I think
BJ.
you're going to go up and stand regardless.
Yeah, Kitty is fine.
Hey, how's it going?
Hey, Edward, how are you?
Oh, we got someone write this shit down. Anyone write this shit down?
smoke you in your car?
My car. I don't have my card here.
I fuck your bitch like I'm Ray
If you
J.
give it to the police officers inside, they can get back to you. If they don't return it, we can. I'll reimburse you or
Cooking
something.
it up like I'm Ramsey.
Sue them.
I fuck your
Hey, we could
bitch
do
like
that too.
I'm Ray J.
Hell yeah.
All right, let's get away from the freestyle rappers over here.
Alrighty. Oh, I'm getting a call. Give me 1 second.
Yep.
Hey,
Nichols, how's it going?
There's super famous people over there.
Who's super famous?
That's Jax. He has 37,000 TikTok followers.
Oh wow, really?
Yeah, he used to have 60,000, but he said they were all robots.
Yeah. Okay. Bots have feelings too, I guess. I don't know.
Maybe.
I don't do social media too much. I'm sorry.
Yeah, Kitty just runs the blog. She doesn't know about other things.
Yeah.
But you know, he said he was famous, so he must be.
Yeah. So yeah. So it'll be my opening statement, prosecution's opening statement. They'll call witnesses. I'll cross-examine, and then it'll be our opportunity to get you guys up on the stand. Like I said, if the arresting officers for your situation aren't here, it'll be in our favor because then I can just ask you questions and no one will be able to sit there and refute them.
Okay.
Like I
cool.
said, you know, the questions, especially if they are especially when they cross-examine, don't elaborate on the questions, right? Just yes, no.
Hey, Eddie.
You know, things like that. So.
Okie dokie. Sounds cool.
Eddie, all right. So just I don't know if you know court proceedings. It'll be my opening statement, then the prosecution's opening statement. The prosecution will call witnesses. I'm sure they'll call Nicholas Thompson up first, and then Cassandra Cohen. Or, I mean, actually I don't know, but the three witnesses that are subpoenaed are Cassandra Cohen, Alex Johnson, who are the witnesses from the cemetery.
Here for the court case starts.
And then Nicholas Thompson, and they may call you and Kitty up. If any questions they ask, don't elaborate, right? Listen to the question, answer short answers, yes, no, okay? Don't give them anything additional to ask follow-up questions, and then I'll do my best to object to anything that I feel is inappropriate. And then when it's our turn, you know, we'll see how it goes, and then we'll bring you up to stand and yeah. All right, answer
Super cool.
answer truthfully to the best of your ability. With that, and obviously, you know, don't perjure yourself. But you know what I don't know, right?
Yeah, totally.
Okay. All right. Just yeah. And anytime during the case, if you need to speak to me, just kind of whisper. You know, get my attention, wave your hand or something, and whisper. I'll walk over and whisper, and we'll talk. Okay.
Alrighty.
All right. Let's get in there.
Alrighty, mate. I'll see you in there.
Oh yeah, that's the girl going in. What did she go for? Thatcher, calm down. How are you sweating in the snow?
Oh, Val Killmer.
No toxins.
Sports Center top 10. I'm
Are
on
the doors
freestyle
locked
that
still?
shit right now.
Mm-hmm.
Yo, Kitty, tell me what you
Are
think
we
about this
allowed in?
lyric.
Are we allowed in yet? I guess we are.
Mm-hmm.
That's a song already, buddy.
Alright, Jenna, come on down, Dre. I'm just gonna quickly pat you down, make sure you
Hey.
have nothing on you that you shouldn't
Uncle
have.
Maxwell, how are you doing?
Alright, I'm good. Got you good to head
If you want
in
to make a
on-
second
head on
line
in.
over here, you're more than welcome to.
Thank you.
Let me just make sure it's unlocked.
Yeah. Hey, do you know if
God.
by any chance if
What?
Clayton Knox, Finch, and Denoza are
Yeah,
around?
I'll hold on to it for you, Bill.
I don't believe they are.
Okay. It's locked.
Alright, Kelly, you good if I search you?
Go
Make
for
sure you have
it.
nothing on
Alright,
you.
you're good, Bob.
Thank
Go
you.
ahead.
Alrighty, thank you so
Feel free to
much.
take some Skittles.
Alright, you're good to head on in.
Okay, thank you.
Alright. Oh.
Alright. No worries,
she
you're
meant-
good.
Been cleared.
Hello, are you all clear through?
You're good.
Yeah, we're all clear through.
Hello there, man.
Thank you. Oh,
Oh my god.
But
crap.
What you got? Let's see.
All right, Edward, you and Kitty can take a seat.
You're good. Go, Bill.
Oh, Eddie disappeared.
What?
Oh, there you are.
Tackle me real quick.
Good. You're good.
Can you take off your shoes real quick?
Alright, you're good.
Yeah.
Hello. How are you?
I don't know if I can take off my shoes because I don't have any on, man.
Okay.
Let's see.
That's right. As long as you're sitting, I'll always refer to you as long as you're sitting there.
You want me to hold on
What
to
on
it?
now?
You want to put it somewhere? Okay.
No, I still can't see.
All
Hold
right.
Fuck.
Alright, you're good.
on. I'm gonna take a quick nap.
Alrighty.
If anybody asks for me.
Yeah, let him know.
Hey, Bill.
Oh. All right, we're having some technical issues because I can't see people, so we're just gonna restart that whole nonsense. Hopefully I'll get back in. quickly. All right.
Oh my god!
Yeah.
Share it with me.
What's that?
Your blog. Share me your blog. I want to see it.
Oh, okay. Here, you want to pose for it? Okay, let's hold on. Okay, here we go. Pose for the blog.
Hell yeah!
Perfect. Oh wait, do you want to do that? Hold on.
Yeah.
Hold on, Kitty's got this. Okay, perfect.
Hell yeah!
My good.
How do you spell your name again?
E-D-W-A-R-D. Edward. And then Dahmer is D-A-H-M-E-R. Dahmer.
Okay, great. Here you go.
Hell yeah!
It's on the blog.
Hell yeah! Hey, you guys, pose for the photo.
Jeez.
Just taking my good side.
Peace.
All right.
Sweet.
Cool.
All right. Just remember, when the court is in session, we're only going to speak when we're spoken to, right? And try to if you have anyone in the stands that are here for on your behalf, just let them know not to make any outbursts.
Okay, cool.
It'll make it.
All right.
We want to minimize any agitation from the prosecution or the bailiffs and the judge, obviously, as well.
Yeah, for sure. They're really powerful.
Indeed.
Kitty feels super uncomfortable without the mask.
Did they make you take it off outside?
Yeah.
Yeah, I thought they would.
Yeah. No, Kitty told them that the last officer that took it off said, no, never mind, let's put it back on. But that's okay. It's totally not gonna derail anything. Wow, it's a great picture.
Thank you. Hell yeah! So many support. You're ready to hypothetically kill them? Or metaphorically?
Sorry, what did you? Were you talking about?
Yeah, you ready to metaphorically kill them?
Attorney for the defense, we can hear you in the gallery.
Yeah. Okay, let's get down to a whisper. What were you saying about metaphorically killing somebody?
Said you ready to metaphorically kill them?
No.
Come here for a minute.
Don't kill anyone.
Whispering, don't worry. It's just a TikTok. It's a joke, man.
Oh, okay. Sorry, I was just going over the opening statement in my head.
Where are they?
Oh, you're alrighty.
Yeah.
Who called me?
Over here.
Oh.
Yeah, so yeah, I don't think the arresting officers for Kitty are here. You were only arrested by Nicholas Thompson, correct? He was the only one that was there when he apprehended you?
No, there was 2 other officers.
Oh, with him, okay.
Yeah.
So one thing they're gonna ask you is what were you doing in the I forgot to talk to you about this.
The alley.
What they're gonna ask you what you were doing in the alley.
Alrighty. Well, I don't have a place to live, so I was in a comfy little alley. Took a nap.
Okay.
Bless you.
That's gonna be it's a thin alibi, but it still doesn't place you at the location because they don't have the clothing. So
true.
So okay, that's it. I'm not really concerned about anything else. I'm like I said prior to the opening statements, I'm gonna motion to move to dismiss all charges against you because the evidence is paper thin, and we'll see what the judge says. But
hoping the judge is a nice person.
yeah, I've never dealt with her.
Who is it?
Dolores McGowan.
Oh, yeah, I've only talked to Cassandra Cohen before.
All rise, the court is now in session. The Honourable Judge McGowan presiding.
All right, stay standing. Go ahead. Where's Kitty?
Hello, you may be seated.
All right, Kitty and Edward, go ahead and take a seat.
Woo, Kitty. Yeah.
My name is Dolores McGowan. We are gathered here today to hear the arguments for CM124, the State of San Andreas versus Edward Dahmer and Kitty Killmer. Some house rules before we begin. I expect everyone in this courtroom to remain civil and respectful. To those in the gallery, please keep your voices down. If you cause a disturbance or a disruption, you will be escorted from this courtroom and you may be charged with contempt of court and possibly obstruction of justice. With the rules covered, I would like to introduce Detective Robertson, who will be acting as bailiff during this proceeding. I would also like to thank the officers at the back of the courtroom for their time and service, as they are here for everyone's protection. Defense, will you please rise and introduce yourself to the court?
Yes, Your Honor. My name is DeAndre Evans. I'm a senior public defender with the Public Defender's Office.
Thank you. And the defendants.
Hello, this is Kitty.
How's it going? Edward Dahmer here.
Wonderful, you may be seated.
Okay.
Prosecution, please introduce yourself to the court.
Good evening, Your Honor. Cyrus Hunt appearing on behalf of the state.
Thank you very much. And you have a second chair?
Yes, Your Honor, for the state as well as Oliver Hall.
Perfect. And I see you there, Mr. Ross. Prosecution, will you please read the charges?
Yes, Your Honor. Both the defendants, Edward Dahmer and Kitty Killmer, are being charged with 1 count of assault, 1 count of kidnapping, 1 count of torture and mutilation, 1 count of fleeing and eluding by foot, and 1 count of unlawful possession of a Class 1 firearm.
Thank you very much. Defense, how do you plead?
The defense pleads not guilty. May I approach the bench with the prosecution?
Yes.
Your Honor, based on the lack of substantial probable cause or any probable cause on behalf of my client, Mr. Dahmer, I'd like to motion to dismiss all charges against him. I don't know if you've read the court document, but they literally have no probable cause on his behalf currently.
I have read the court docket. Mr. Hunt, what would you like to say?
Yes, Judge. Through the evidence that we'll present during the trial, we do intend to prove both the defendant's guilt beyond a reasonable doubt. And we would ask that we be allowed to be given that chance during a court proceeding where we actually can present our evidence.
Mr. Evans?
I mean, if you look at the arrest report and the charges that were placed based on voice ID.
Defense, you're yelling.
Oh, pardon me. If you look at the arrest report and what was presented.
Oh, sorry, now I can't hear you at all. Come on.
There's that fine line.
Right.
Sorry. If you look at the arrest report, Your Honor, and what was presented, the only probable cause that the arresting officer with Mr. Dahmer that was presented was identification based on voice and previous experience. But by all accounts that were presented, the individual, the alleged assailant on scene, was completely dressed in black with a helmet, with no identifying features. So I'm not sure where this identification came from.
Respectfully, I would disagree with your assertion of lack of probable cause. I have read the same docket as you. I'm also a little bit curious as to why you wouldn't have brought this up before.
It was something that was discussed, and again, something that was brought up immediately before the trial by as a desire by my client. So.
Okay. Your motion your motion is denied. We're going to proceed on with this matter. And do you have any other questions that you'd like to bring up before we start?
Nope, understood. Appreciate your consideration.
You know, just for clarification, is it just simply Mr. Dahmer that's pleading not guilty, or is it both defendants?
Both defendants are pleading not guilty.
Oh.
Okay.
Understood.
All right, thank you. All right, I put forth a motion to dismiss all charges against you, Edward. They denied it, so.
Prosecution, please present your opening statement.
May it please the court, counsel. The evidence in this case will show that on the 30th of October, the defendants, Edward Dahmer and Kitty Killmer, kidnapped Ice Williams and took the victim to the graveyard. You're going to hear testimony today from Sergeant Nicholas Thompson, who works with the Blaine County Sheriff's Office, and he was one of the first officers to arrive on the scene. When he arrived, he saw the defendants standing with the victim, and Miss Killmer, she had a bat in her hand. the sergeant approached the defendants, and when he started approaching them, the defendants were talking about the victim's blood and what the victim's blood tastes like. Nicholas Thompson spoke with the defendants at one point, and he got them separated away from the victims. When he had them separated away, he noticed that the victim was bleeding from his wrist, and when he was bleeding, he was also missing a pinky finger. At that point, he went to go check on the victim. When he checked on the victim, the two defendants, they started running from the police. They wouldn't surrender, and they didn't surrender, and they had no intention to surrender. Sergeant Nicholas Thompson will testify to the fact that he identified Edward Dahmer on the scene. And that is the reason that he made the decision to chase Miss Killmer. Miss Killmer was arrested on the scene. There's no dispute about that. Law enforcement later found Edward Dahmer running in an alleyway between West Eclipse and Cougar Avenue, and that's all going to be testified to. When he was found, they also found some clothing ditched inside of a garbage bin nearby. You're also going to hear someone testify by the name Alex Johnson. Alex Johnson was at the graveyard with Cassandra Cohen. Alex Thompson, he saw the two defendants, and he saw the victim, and he made the conscious decision, like anyone would, to call 911. Once you've heard all the evidence, with the overwhelming amount of testimony, you will see, and it'll be quite clear, that both the defendants, Edward Dahmer and Kitty Killmer, are guilty on all of the 5 counts. All of them. And there's no excuse. Thank you, Your Honor.
Thank you, Mr. Hunt. Mr. Evans, your opening statement.
Thank you, Your Honor. Good evening, Your Honor, ladies and gentlemen of the court. I stand here before you this evening in defense of my clients who are being falsely accused of assaulting, kidnapping, and being involved in torture and mutilation of the alleged victim, Mr. Ice Williams, who, by the way, was subpoenaed to appear in court today, but was unavailable at any time I tried to reach out to him. The prosecution will present to us several witnesses and law enforcement officers who will testify that they saw and heard things that will ultimately not prove, beyond a shadow of a doubt, that my clients, Mr. Dahmer and Ms. Killmer, were in fact involved in any criminal activity on the day in question. They will be unable to present any real physical evidence to substantiate their claim against my clients. Thank you.
Thank you, Mr. Evans. Prosecution, you may present your first witness.
Your Honor, the state calls Alex Johnson to the stand.
Mr. Johnson, if I can get you to raise your left hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth? Then you may be seated. Your Honor, the witness is sworn in.
Thank you.
Good afternoon, sir.
Good afternoon.
Sorry, could you just state your name for the record?
Alex Johnson.
All right, Mr. Johnson, where is it you work?
Work for the Department of Justice, State Prosecutor's Office.
Just very briefly, what are some of the daily things you do on a day-to-day basis?
Anything from... Apologies. Anything from going to the little teapot to hanging down out at the airport.
And do you recall being at the graveyard on the 30th of October?
Yes, sir.
And what did you see while you were there?
Yeah, I'm good.
Saw a vehicle, red in color, I believe it was a Fudo, come into the graveyard, driving pretty recklessly on the hill, and then park up beside the church. Once they parked up beside the church, I saw 2 individuals.
Sorry, can you just give us 1 second?
Okay.
Oh, sorry. Johnson. Okay. I guess he doesn't need to be here anyways. There's someone yelling in the back, and that's all I can hear.
Can whoever is speaking loudly in the gallery, please keep your voice down. This will be your only warning. Thank you.
Okay. Sorry, we're just gonna rerun from where we were, if you don't mind. So what did you see when you got to the graveyard?
So, like I said, I saw I believe it was a Fudo, red in color, pull up pretty recklessly through the graveyard. Park up beside the church. I saw two individuals get out, the female with a bat in her hand, and then pulled somebody out of the trunk. At that point, 911 was dialed. And myself and the individual I was with, Cassandra Cohen, saw the victim, saw the LEO arrive, talked to the LEO, and then the victim came over to myself and Miss Cohen.
Okay. And you said pulled out of the trunk. So where was the victim?
From what I can recall, he was in the trunk of the Fudo.
So they weren't in the back seat or anything like that?
Not that I saw, no.
Okay. Could you refer to the docket for me for 1 second?
Okay. You're gonna have to give me just 1 second here.
Sure.
Okay, I have it pulled up.
And there's a photo. It's labeled as vehicle used. Do you see that photo?
Yes, I do.
Is that the car that you saw on the 30th of October?
That is correct.
Is this a true and accurate depiction of the vehicle?
Yes, correct.
Judge, we'd offer both of those photos. We'd ask them to be labeled as States Exhibit 1 and, States Exhibit 1 and 2.
So noted.
And did you make any calls on the 30th of October?
Objection, asked and answered. The witness already said he called 911.
He didn't specify only 911, so I'm going to let him proceed. Overruled. Go on, Mr. Hunt.
Did you call anybody on the 30th of October?
More than likely. At that point, I was still a paralegal with the Department of Justice, so I was making phone calls on behalf of the department. I don't specifically remember who I called. Other than 911, of course.
Okay, so you made a 911 call. If you could you say what you said in the phone call? And you can reference the exhibit if you like.
Yes, sure. Basically told the dispatcher that answered the 911 that dudes are driving through the graveyard. They hit a local and they have weapons out. I kept it as brief as I could. Wasn't sure what was going on.
Okay. And do you see the photo of the 911 call?
Yes, I do.
And is this the phone call that you made to the police?
This is correct.
Your Honor, we'd offer the 911 call as States Exhibit 3.
So noted.
And what happened after that while you were looking at what all happened?
So, like I stated, the officer, I believe it was Thompson, arrived on scene. At that point, do forgive me, it has been over a month, so I'm trying to recollect here. When Thompson pulled up, myself and Cassandra Cohen approached him, basically informing him of what was going on. He was the only unit, so he took his time to approach.
So I'm just going to stop you quickly. What did you tell him?
Who, Thompson?
Yep.
Basically what we saw, that the individuals that were in the vehicle were driving pretty recklessly throughout the graveyard, pulled up. One of them had a bat, basically informing him of everything that was ongoing.
Okay. And I know you ran through it pretty quickly, but can you give us a little bit more in greater detail about what all you saw?
Again, objection, asked and answered. This is the third time the witness has stated the same thing.
Your Honor, he gave a short version of what happened. I'm asking him to give the extended version of the incidents that unfolded on the 30th of October.
Can you specify specifically what he should be answering?
Sure.
Thank you.
I don't want to get too direct here, but how long were you watching them for?
If I had to give it a rough guess, it was about 3 minutes before they took off.
And have you seen people kidnapped before?
I have, yes.
Did this look like the victim was with them willingly?
No, it did not.
Objection,
you
Your
say
Honor, that
that?
was leading.
Sustained. Please continue, Mr. Hunt. Or
What did-
rephrase.
Sure. What did the victim look like when he was there?
It looked like he didn't want to be there as he was being held essentially at bat point.
Tell me a
Objection, Your
little
Honor,
more
that's
about that.
That's an assumption.
Your Honor, it's not speculation. He saw it with his own 2 eyes.
He's assuming the mental state of the alleged victim, Your Honor. He can't possibly know what was going through the victim's head.
Your Honor, he testified to the fact that the defendant was holding a bat to the victim's head. I don't see where the assumption is in that.
Again, Your Honor, he can't possibly know what was going on in the victim's mindset.
We're not asking the witness to speak to the defendant's state of mind, just what he saw.
Understood. I'm going to overrule that objection. Go on. Please try to get to the point.
Go ahead, sir.
Can I have the question re-asked once again?
Sure. So you said the victim didn't look like he was there willingly, and I just asked you, why do you say that?
Yes. So, like I was saying, he had the female had the individual who, or the victim in this case, at that point. Once we actually ended up getting the victim over to a relative safe location, he was stating that he had been kidnapped and that he was not there willfully, and just going along those lines with what he was telling us.
I'm sorry, what did he say to you? I didn't hear that.
You're fine. Once the individuals took off, the female and male, the officer instructed us to stay with the victim. The victim came over to us. We were talking with him, trying to get him to calm down. He was relatively hysterical, and was talking to him, and that he was saying he was being kidnapped and that he wasn't there willingly, and he couldn't believe one of his fingers was gone, and he was more or less.
Objection, Your Honor, the answer is in the narrative.
Sorry. Explain.
The witness's response to the question is a narrative, not directly answering the question of the prosecutor.
Mr. Hunt?
Your Honor, he is answering my question. I mean, I can break it up if you'd like, but
that would be appropriate, Your Honor.
All right. Let's have shorter responses to more direct questions, please.
Okay, so you stated earlier that he said to you that he wasn't there willingly. Can you explain a little bit more about that?
There's not much to explain there other than, like I said, he was explaining that he had been kidnapped.
And he told you that?
He did, yes.
Okay. And his pinky finger was cut off. Did he tell you anything about that?
Not directly, no.
Okay.
Other than the fact that he couldn't believe his finger was missing.
And could you describe what you saw when you were looking at the defendants?
I'm sorry, re-ask that one more time.
Sure. When you had originally saw the defendants, what were they wearing? What did you see? What did they look like?
If I may reference my notes, because I do have it wrote down. And I apologize, I've got a lot of notes here, so do forgive me. So I've got the female individual. She's as far as I could tell, didn't have a mask on. She had it was, if I remember correctly, it was blonde hair at the time, pulled up into 2 buns on opposite side of her head, a orange sweatshirt, I believe it was, with a thigh holster. As for the... I apologize.
No, go ahead.
As for the male, from what I could tell, it was black. I couldn't tell if he had a mask or if he had a helmet or what, just because of the distance I was at. But he was wearing a black shirt with either orange or kind of dark khaki pants, anyway.
Okay. And did you ever see the defendants, Edward Dahmer and Kitty Killmer, run off at some point?
I watched both of them run off, yes.
You saw it with your own eye?
Objection, Your Honor. they're assuming the identity of the individuals who were clearly just identified by Mr. Johnson as being at least one of the alleged being completely covered. So I don't understand how Mr. Johnson is identifying Mr. Dahmer.
Mr. Hunt.
I can really only rely on what the witness has said. The witness has said that when I asked him about the defendants running away, he said that the defendants were running away.
Mr. Evans?
I mean, the witness just tried to identify my client as being one of the individuals running away when, by all accounts, one of the
I can just
individuals was completely covered up.
Understood.
Did you see 2 people running away, sir?
Yes, I saw 2 people running away.
Okay. And was it 1 male and 1 female?
Correct.
I have no further questions, Your Honor. Thank you, sir.
All right. Mr. Evans, your opportunity to cross-examine the witness.
Thank you, Your Honor.
No, I do.
Mr. Johnson, initially in your 911 report, you stated 2 dudes in a vehicle. Can you expand on how that description came about?
If I might re-verify just off of the docket, Your Honor.
Absolutely.
I never stated 2 dudes per the 911. It was, and I quote, dudes are driving through the graveyard, hit a local, now pulling out weapons. I never specifically identified two male individuals.
My apology. The 911 call that was placed into evidence clearly states dudes, which implies males.
Judge, we would object. That's misrepresentation of the evidence. The 911 call says duds, not dudes.
Yes, I would agree with you.
Okay, can Mr. Johnson, can you explain what a dud is?
It must have been the dispatcher with a bit of a typo. As for the dudes, that is a general term for individuals that I use on a common basis, not gender specific in this, as you're insinuating.
Your Honor, the 911 call was made by Mr. Johnson, so I don't understand how he can attempt to blame the dispatcher for
Judge, we'd object as the counsel's testifying.
Yeah, I'm going to say let's not argue the semantics of the word dudes in this context. Please move on with your questioning, Mr. Evans.
All right. Mr. Johnson, is it in your is this your assessment that anytime someone holds a baseball bat around someone else that they are assaulting or holding that person against their will?
Not at all.
Okay. And on the dating question, can you re-verify what you saw the 2 individuals wearing, please?
I'm sorry, ask that one more time. I'm having issues with my ears.
Can you please describe the clothing of the 2 individuals that you allegedly saw at the cemetery?
Yes, sir. I'll give you the information if I can reference my notes one more time.
Sure.
The 2 individuals I did see.
Sure.
And once again, I apologize. These notes are buried. All right, the female individual had blonde or dirty blonde hair with not necessarily pigtails. I'm not sure what they're called. The little round balls on either side of her head, with an orange, I guess, sweatshirt, bright orange with a thigh holster. The male had black shirt, from all I could positively see, black shirt and either dark like brown or dark khaki pants.
Okay, thank you. And in your previous testimony, you said that you were at quite a distance from the 2 alleged assailants. Is that correct?
When I had wrote the notes, correct.
Okay. Can you give us approximately how far away from the alleged assailants you were?
For me to get an accurate estimation, I'd have to go back and see. I haven't visited the graveyard since. If I had to give you a rough guess, 150 meters.
Bullshit everywhere.
150 meters. Would you say that that distance was far enough to make your ability to identify the individuals difficult?
I apologize once again, my ears. Can you re-ask the question?
Would you say a distance of 150 meters is far enough for you to make identification of the individuals difficult?
Depends on the individual's eyesight. For myself, most of the time.
Okay. And could you please tell me if you see those individuals that you saw at the cemetery in this courthouse today?
As of this time, I could positively identify Miss Killmer. I believe that's how you pronounce her last name. Apologies if it's not.
Okay. And with regards to the victim himself, who, again, I remind the court that he was subpoenaed and did not appear. Would you, in your experience as a state prosecutor, have you ever had a victim claim to be attacked in order to protect themselves?
Objection, relevance.
The victim, Your Honor, claimed to be attacked to the witnesses at the scene.
Your Honor, he's asking relevant questions as to his experience as a prosecutor, nothing to do with this case, and there's nothing to indicate that any sort of witness or victim was faking what happened.
Your Honor, the witness is a state prosecutor. He has tried plenty of criminals, and I'm asking based on his experience if these types of alleged
yeah, that's
statements
actually
have been
incorrect. He hasn't tried any cases.
I'm aware.
Okay, I'll rephrase, Your Honor.
Please.
Mr. Johnson, do you believe it possible that a victim could claim to be a victim in this scenario in order to avoid prosecution?
Objection, speculation, improper expert opinion.
Sustained.
Your Honor, he's a state prosecutor. I would say that he's an expert on criminal investigations.
The speculation came from your question, Mr. Evans.
Okay.
If you would like another opportunity to rephrase or move on.
No, that's right. I'll move on. Just to clarify one last time, you are asserting that you can 100% identify Miss Killmer from 150 meters, based on your own eyesight?
If I might, Your Honor, I was, in regards to the 150 meters, that's when I took the notes. I positively identified once I moved closer, once the officer had arrived. Correction deputy.
Okay.
Okay. Nothing further then, Your Honor.
Thank you, Mr. Evans. Mr. Hunt.
Sorry, I just got a couple clarifying questions for you quickly. Promise I won't take up too much of your time. Okay, so we talked a little bit about duds. Doesn't really matter, but did you see a male and a female there?
Yes, I did.
Do you have any doubt in your mind that you saw a male and a female?
Absolutely not. No doubt in my mind there was a male and a female that exited the vehicle.
And he talked a little bit about baseball bat means assaulting someone. Do you remember that kind of questioning?
I do, yes.
It was kind of weird, though, because she had a baseball bat, the victim had his pinky cut off, and his wrists were bleeding, right?
That is correct.
So it wasn't just a baseball bat, was it?
Correct.
Leading, Your Honor. Objection, leading, Your Honor.
Sustained. Please be more direct, Mr. Hunt.
Okay, you talked a little about 150 meters. Can you explain when you actually got closer?
Yes, so the 150 meters, I guess there's a bit of a confusion here, so let me clear this up. The 150 meters was when I took note of the individual's appearance. Upon calling 911 and moving closer to the deputy, Thompson, I believe it was, at that point, that is when they took off, and I could positively identify Miss Killmer. Sorry, correction, or I apologize for my stammering.
So at one point, you were pretty close to them, weren't you?
Leading,
yes, sir.
objection, Your Honor, leading.
Sustained.
Judge,
Go on. Please rephrase or get to the point, Mr. Hunt.
sure. At one point, were you closer to them?
Yes, I was.
And he talked a little bit about the victim claiming to be attacked. Do you remember that kind of questioning?
Yes, I do.
What else did you see on the victim other than just the claim of being attacked?
As I stated,
Objection, Your Honor, hearsay.
Yeah, I'm asking what you saw. I'm not asking about any third-party conversation.
Overruled. Continue, Mr. Hunt.
So I can repeat the question?
No, I've got it.
Okay,
So
go.
yes, there was the claim of the baseball bat and the assault. There was also the overlaying missing pinky finger as well as blood dripping down to his entire hand.
And he wanted to talk about your experience. So let's talk about your experience. In your experience as a state prosecutor, did you believe that he was lying?
No, I did not.
I have no further questions, Judge. Thank you.
Thank you, Mr. Hunt. Mr. Evans, your opportunity to recross.
Mr. Johnson, you stated earlier, well, the prosecution objected to utilizing your limited experience as an expert witness. So, in that same line of questioning, how are you able to ascertain the status of the victim while also not being able to ascertain whether an alleged assailant could possibly pose and say that they were a victim?
Your Honor, I'm going to object for counsel's testifying in ambiguous. Could counsel rephrase or re-ask the question?
Do you believe that? Do you believe that? Do you believe that you're limited? So is it your assertion, Mr. Johnson, that in your limited role as a state prosecutor that you can determine whether someone is lying, but you can't determine whether someone whether someone is lying, but at the same time you don't believe that the prosecution doesn't believe that you can determine if he was lying about whether he was a victim or not?
Your Honor, same objection.
Could you be a little bit more succinct?
No, withdrawn, Your Honor, withdrawn.
Okay.
Nothing further, Your Honor.
Thank you very much. Mr. Johnson, you may be seated. Please remember you're still under oath.
Yes, Your Honor.
Prosecution, your next witness.
Yeah, and I believe our other three, we do have one more, but I believe the other three witnesses aren't here, but just make sure I do, I just want to make sure I call them, see if they are here. The state would call Senior Officer Clayton Knox. I don't believe he's present, but the state would call Riviera Finch. And the state would call Ignacio Denoza, but I know he's not going to be present. Your Honor, the state calls Nicholas Thompson to the stand.
Okay.
Thank you. Forget to raise your left hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth? You may be seated. You're the witness sworn in.
Thank you.
Good afternoon.
Good afternoon.
How's your day going, sir? Sorry, how's your day going?
It's going all right.
It's good to hear. Could you say your name for the record, please?
Nicholas Thompson.
Mr. Thompson, where is it you work?
Blaine County Sheriff's Office.
And what's your role at the Blaine County Sheriff's Office?
Sergeant.
Okay. And do you recall responding to a kidnapping on the 30th of October?
I do.
Can you explain a little bit what happened?
So we received multiple 911 calls at the graveyard just off of West Eclipse Boulevard, stating that there was possibly a hostage behind the church. I arrived on scene and observed the two individuals, one of them, the female, having a baseball bat with the victim in front of her.
Okay. And what did you see from there?
I approached on foot, but I observed the female with the baseball bat, so I ordered her to put it away, which she did, and I made my presence known, identified myself, and started approaching. That's when I started talking with the suspects to try to get the victim away from them because I didn't want it to turn into a hostage situation.
Okay. And you stated, I don't know if this was you that wrote this, but in the report that somebody had a black motorcycle helmet with a matte black visor. Was that you that wrote that statement?
Yes.
Okay. Could you explain who was wearing that?
It was the male suspect.
Okay. And was he wearing that the whole time?
I believe at some point, as he was starting to run away, he ditched it, and there was another face covering on that he had that only partially covered it. I believe it was a bandana.
Okay. And I want to make sure we don't get confused here. So just for going a little bit easier, we're going to talk about Miss Killmer first, her situation, and then we're going to dive over to Mr. Dahmer. All right?
Okay.
Okay. So when you walked up to the victim and you saw the two defendants, what happened when you separated them?
They were the two defendants, or the subjects, stayed in place for a little bit. I was able to get the victim to walk towards me and get them separated. I observed the injuries that the victim had. His wrists were bleeding, and he was holding his hand where his pinky was missing. So I started backing away with the victim. That's when the two subjects began to run away. So I left the victim in the hands of the two witnesses. I told them to provide medical attention and transport him to the hospital if need be. And that's when I went after the suspects.
Okay. And did both of the suspects stay together the whole time?
For the beginning, they did. They were sort of walking in the area of the church. When they split up, I stuck with the female.
And what happened when you stuck with the female?
The male ran off. I tried to radio in his position for as long as I could see him, and the female ran southbound across the road, so I continued following her into an alleyway.
What happened from there?
We jumped a fence, and that's when I once again saw the other subject, who was now, he had ditched his clothing and was laying next to the dumpster. We continued running through that alleyway, and she was caught just out on that the road south. I believe it's Cougar Ave.
Okay. And at one point, was she arrested?
I'm sorry?
And at what point was she arrested? Sorry, at
shortly
one point?
Shortly after we exited that alleyway.
So she was arrested on the scene.
It was just south of the scene.
Okay. And her clothing never changed throughout the way? She was wearing the same thing the whole time?
No, I had contact with her the whole time.
Never lost sight of her?
No.
So before we move on to Mr. Dahmer, I just want to talk about each charge. You did charge the two defendants, right?
Yes.
And what was the reason for the assault charge?
She had the baseball bat in the direction of the victim, and he appeared to be there against his will.
Okay. And what was the reason for the kidnapping charge?
He was taken without authorization.
And the torture and mutilation?
His pinky was removed, and his wrists cut.
And the fleeing and eluding?
They both ran for me.
And then the unlawful possession of a Class 1 firearm?
One was recovered from him without a serial number on it.
Okay. You said on him, so one wasn't found on her as well?
Negative.
Okay.
She had the baseball bat.
Okay, so we talked a little bit about that. I want to go back to Mr. Dahmer. But before I do that, did you personally take any statements from the victim?
I did afterwards, but he wasn't very. The answers that he was giving weren't.
Sure. Could you explain what he told you?
He explained that he had been taken at gunpoint, although he didn't say from where.
Okay. But he told you he was taken at gunpoint.
Yes.
Did he tell you anything else?
They were talking about tasting each other's blood when he was in the vehicle with them, and that they were going to be friends.
Okay. And did you hear Mr. Johnson testify here today?
Yes.
And he testified as well that he actually heard those statements?
Yes.
Okay. I want to talk a little bit about Mr. Dahmer now. So when you arrived on scene, actually, I'm just going to jump ahead. So you spoke with the two defendants on the scene, right?
Yes.
Okay. What did you talk to them about?
So when I arrived on scene, the male was the first one to talk to me, and I tried to find some common ground so that I could distract them and try to get the victim away from them, and that's when I was having some small talk. I don't know exactly what, but at one point I called him by his name, which he
I'm
responded
sorry,
to.
what name is that?
Edward.
Edward. Okay. And then, sorry, keep going.
He responded to it, so I was having some small talk. Again, I don't know exactly what I said, but we were talking. And then the female defendant, I remember her talking in sort of a third person. So whatever she said, it was Kitty, and then whatever she was going to say.
So they both identify themselves on the scene. Is that a fair statement?
Yes.
Okay. And you decided to pursue Miss Killmer, and I'm going to get to the identifying, but you decided to pursue Miss Killmer because you identified Mr. Dahmer, one of the defendants, right?
Yes.
So, what I'd imagine, sorry, one moment here. I imagine the defense counsel is going to come up here. Sorry about that. I imagine the defense counsel is going to come up here and say that essentially you
Objection,
never
Your Honor.
identified Mr. Dahmer. Sorry,
Mr.
Judge.
I would sustain that. Please be more direct.
Sure. So they're going to go up here and say that you never identified him, blah, 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 whatever, who cares? But what they're not going to talk about is you actually know Mr. Dahmer quite well.
Objection, Your Honor. Inflammatory.
How's that inflammatory?
Because you're creating prejudice against my client, sir.
Your Honor, the officer is about to testify that he's previously encountered Mr. Dahmer on numerous occasions.
It still creates prejudice, Your Honor.
Your Honor, it goes to establishing identity of one of the defendants.
Rephrase your question, Mr. Hunt.
How did you identify one of the defendants, Mr. Dahmer?
So he is my best friend's adopted son and my adopted son. So when I was talking with him, I had known him already, so.
Okay, so let's talk a little bit about that, because so you know Mr. Dahmer quite well. You said, sorry, what about a son? I didn't understand that.
So my best friend Barry Hill legally adopted Edward Dahmer and his sister River, who wasn't involved in this, but.
And how many times have you encountered Mr. Dahmer in the past?
No less than 10 times.
So a lot of time.
Yes.
Have you dealt with him outside of your professional capacity as well?
Yes.
What were those circumstances?
In a more personal setting, we had counseling in which we were all there. It was a family counseling.
Okay, so it's fair to say you know him quite well.
Yes.
And let's talk a little about how he was identified on the scene. So you said he had a half mask covering his face?
Yes.
So what was it? Facial features? Was it the vocal
Objection, Your
recognition
Honor,
as well?
leading.
Can you tell me a little bit about that? Can
Objection, Your Honor, leading.
Sustained. Please be more direct.
you tell me how you identified the defendant?
So when I was making small talk, like I said, I can't remember exactly what was said, but we got to the topic of, I believe he said, "Hey, Pops," or something along those lines. And I called him by his name. I said, "Ed," and he responded to that. And that's as I was making small talk to try to, once again, get the victim away from them.
And so you know him. Does he have a unique voice? How would you describe his voice?
Objection, Your Honor, leading.
I said, how would you describe his voice?
You asked him if he had a unique voice. Objection, Your Honor, leading.
Rephrase the question, Mr. Hunt.
How would you describe his voice?
It is a bit of a unique voice, but it's not. It wasn't the only identifying feature.
Sure. Was there any more identifying features that you didn't mention?
I was able to see his orange hair and some of his face paint.
Okay. And do you see that person standing in the courtroom today?
Yes.
Could you point him out, please?
Yes, he's standing right across from me.
Judge, we'd ask that the record reflect that the witness has identified the defendant, Edward Dahmer.
So noted.
And you made a decision to chase the female. Why?
Because I knew that the other defendant was Edward, so I knew that if I had to, I could put out a warrant for him, but I didn't 100% know who the female was, so if I could get her, that was my main priority.
Was there any doubt in your mind about the identification of Mr. Dahmer?
No.
None?
No.
And how long have you known Mr. Dahmer for?
Now I'd say about a month and a half, 2 months.
2 months, okay. And you saw him, sorry, just so I can understand, you've met with him over 10 times in the past 2 months?
Yes.
Okay, so it's not rare that you see him?
No.
Okay, and earlier you testified that at one point, Miss Killmer and Mr. Dahmer, they caught up to each other at one point when you were jumping over a fence?
Yes.
Did you see Mr. Dahmer's hair at any point?
Yes, he had taken off
Objection,
most
Your
of
Honor,
his...
leading.
Mr. Hunt?
Well, Judge, with all due respect to Mr. Defense Attorney, but if I ask it the other way, he objects to narrative, and if I ask it this way, he objects to leading. So, I mean, he wants to have it both ways.
Can you repeat the question, please?
I asked if he saw or what. I don't recall the exact wording, Judge. I just have to rephrase it.
He described the victim in his question, Your Honor.
Understood. Please rephrase, Mr. Hunt.
So when you saw Mr. Dahmer running, when they both caught up, what did he look like?
He had taken off most of his clothes. I believe he was just down to his underwear, and he was laying next to a dumpster, so his hair was out.
And were his clothes found anywhere?
We found a bag of clothing in the dumpster.
And can you tell us a little bit about that?
There was a black long sleeve shirt and I believe pants. I wasn't the one who recovered it, but I know for sure that the black shirt that he was wearing was recovered.
And how close was he to the dumpster?
He was laying right next to it, up against it.
And what does his hair look like when he was near the dumpster?
It was orange and long. I remember passing by him.
Did it look like the same hair that you had saw just a couple minutes prior?
Yes.
And just for clarity, is there any doubt in your mind that the person you saw wasn't Edward Dahmer?
No.
Thank you, Sergeant. Your Honor, I have no further questions.
Thank you, Mr. Hunt. Mr. Evans, your opportunity to cross-examine the witness.
Thank you, Your Honor. Sergeant Thompson, I've dealt with you a couple times. I know you have a long exemplary record, but can you please describe the laws and ordinances with regards to voice identification as a means of probable cause?
Your Honor, we'd object this to improper expert testimony.
He's a sergeant in the BCSO, Your Honor. If he doesn't know the laws and ordinances on probable cause, I would question a lot of things.
Your Honor, the witness was called as a witness to this case, not an expert as to the law.
The question is in regards to his experience as a law enforcement officer, Your Honor.
He's asking him to state the law, Judge. He's not asking him his experience.
Please rephrase the question. We're aware of what the laws in the state are, at least from this perspective.
All right, Sergeant Thompson, is voice identification satisfactory probable cause in the state?
No.
Evidence for probable cause in the state? Okay.
No, but as stated, there was other identifying features. That wasn't the only.
Sorry, Your Honor, someone just threw a snowball at the...
Excuse me 1 moment. Stand up, please.
But you did assert that when you first came on the scene, Sergeant Thompson, that you immediately identified his voice, and that's why you proceeded to try to call his name, allegedly, or that he
There was also
referred
his
to your
hair.
name. You saw his hair from underneath the motorcycle helmet.
It was coming. Yes.
Come here.
Sorry, Your Honor, I'm just gonna. And you're asserting that the individual on scene responded to the name Edward or Ed, you said?
Eddie.
Eddie. Okay. And could you describe it? So the alleged victim had his wrist cut and I believe his finger cut off. Was there any?
Yes.
Was there any? Were there any weapons found on scene besides the Class 1 pistol?
Baseball bat was recovered from the female.
Baseball bat. Were there any knives recovered from anywhere on the scene or any of the alleged assailants?
I believe one was recovered from Edward after he was taken into custody.
And was there any forensic evidence on the blade consistent with the victim or any of the assailants?
We sent it to forensics, but we didn't hear back.
You didn't hear back, or they didn't give you an affirmative answer?
We would object as an improper form of question. I think the defense attorney knows that he's arguing semantics here, to say the least.
We have an individual passed out in the gallery.
Oh.
Shall I wait? I'll wait, Your Honor.
Yes, thank you. I'd like to take this opportunity to remind you if you have snacks or beverages, you may eat them or drink them in this courtroom.
Edward, Kitty, you guys good on food and water?
Yeah, by the way, they're like capping my G. You know, like, I'm just saying, like, the helmet, the alleged helmet, you know?
Yeah.
You can't see through it, and my hair was tied up. So, like, there's no way he saw my hair, man.
Okay. Oh well. Yeah, I know. I'm gonna bring that up when we bring you up on stand. You guys still want to take the stand?
Sure.
I'm gonna ask you to describe your hair color, Kitty.
No, so
Thank you, detective.
I never ditched my clothes in the dumpsters. I don't know how they got clothes from the dumpster.
Also, Kitty never held up
Mr.
for
Evans,
that.
you may proceed unless you'd
Yeah.
like to ask for a recess.
Okay, thanks.
Nope. I'm sorry, Your Honor. We're good.
Okay.
Has the individual recovered? Okay.
Nah, I'm good. Sorry about that, bro.
Just let me retrace my notes here. Just to confirm, Sergeant Thompson, you are asserting that you were indeed able to see the alleged assailant's hair color underneath the helmet?
Yes, through the visor, and there was some coming out the bottom.
Okay. And with regards to the, so I'm gonna take a page here from the prosecution. We're gonna split the conversation here. I'm gonna move to Ms. Killmer. With regards to Miss Killmer, you're saying that she was holding a baseball bat next to the victim, essentially holding him in place. But when you arrived on scene, you said that you were trying to avoid a hostage situation.
Yes.
Can you expand on that? Why would you be avoiding a hostage situation if they were already holding the alleged victim hostage?
At that point, I believe she was only kidnapped. If I had a chance to get the victim away from them, then I was going to do that. I wasn't going to escalate it into a hostage situation unless they were claiming him as one.
Is it possible that 1 second, I'm sorry, let me rephrase that. So you're asserting that Miss Killmer was in fact assaulting the alleged victim with a baseball bat in her hands. Is that correct?
If by intimidating with the bat, then yes.
Can you describe what you would call intimidation with a baseball bat?
Having it out, brandished.
Just simply having it out. Is it ever possible? Is it plausible in the state that someone could have a baseball bat out and not be holding someone hostage or brandishing it in a threatening manner?
Objection, speculation, improper expert opinion.
Expert opinion on your baseball bat, Your Honor. I'm asking a question of a law enforcement officer who I'm sure has seen many people hold baseball bats in public.
Your Honor, he's asking a hypothetical question, which of course the witness has not been established as an expert witness as far as the law, but I think this is ruled on.
I mean, if we're describing the crime of holding a baseball bat in regards to holding someone against their will, Your Honor, he's a law enforcement officer.
I would say overruled. Continue, please be more direct.
Is it, Mr. Thompson, have you ever held a baseball bat in your hand in a non-threatening manner?
Yes.
Okay. With regards to the victim, you said that he was incoherent or wasn't making clear statements. Is that accurate?
I didn't say very much to the victim. I was mostly talking with the defendants.
Who was directly involved with the victim and handling the victim and taking statements from the victim?
I did take a statement, but it was not conclusive. He wasn't answering the questions very well.
Okay, could you expand on what you mean by not answering the questions very well?
Yeah, we'd object this asked and answered. He answered these questions a little bit ago, and he just said that he wasn't going into great detail about what happened.
Sustained.
Okay. Well, with regards to the victim himself, I'm sorry, Your Honor. Are we not considering Mr. Thompson an expert witness with regards to crimes in the state?
With regard to the law, you can assume that we know and understand what the letter of the law is. If you have a specific question regarding circumstances, etc., please proceed.
Okay. Mr. Thompson, have you ever encountered a situation where a victim claimed to be victim and was later identified as being complicit in the activity?
We'd object this irrelevant. Oh, he already answered the question. Sorry, I withdraw my objection.
He didn't answer the question, Your Honor.
He said no.
This is the first time I'm answering this question, Your Honor. I asked that question to Mr. Johnson.
Understood. Go on. Please get to the point quickly.
I'm sorry, Sergeant Thompson. I'll ask the question again. Have you ever encountered an alleged victim who was later found to be complicit in the activity?
No.
Never.
Never.
Okay. We'll move to Mr. Dahmer here. Going back to the weapons found on scene. Who were the weapons found on?
The pistol with the serial number filed off was found on him.
And you said there was a knife found on scene. Where was that found?
That was found on Edward, but I wasn't the one that took him into custody.
Who did take him into custody?
I believe it was Rivera Finch.
Okay. On the arrest report itself, you did describe your interaction with Ms. Dahmer with regards to him answering to his name and a voice identification. The information regarding the attire and the hair were all omitted. Can you tell me why that was?
During the time of processing, I was just putting down what I remembered at the time, and I can recall the situation better.
So you're saying that you remembered a situation 1 month later better than the immediately after the incident?
There are things
we'd
that
object this argument.
Sustained.
Sergeant Thompson, you are asserting that you remember the events from a month ago better than the day of the incident.
Your Honor, same objection, Judge. I objected to this, and it was sustained.
It's a direct. Is it typical, Sergeant Thompson, for reports to be incomplete on the day of the filing?
Yes.
Okay, and what? So what? 1 second, Your Honor. Edward,
Yeah?
you said your hair was up, right?
Yeah.
Okay.
And the helmet, you know, you can't even see through that shit, man. It's got reflective fucking glass.
Yeah. Okay. With regards to the identification of Mr. Dahmer, when he was apprehended in the alleyway, was he wearing the same clothing as the alleged assailant at the cemetery?
We'd object. That's asked and answered.
Sustained. That has been asked and answered.
Okay. The items in the items that were found in the dumpster. Could you describe those items again for the court, please?
So I was not the one that found them, but based on the officer that did, it was a black T-shirt, and I can't exactly remember the pants, but they were matched up to what he was wearing.
Can you describe what he was wearing?
He was wearing a black long T-shirt with a puffy neck, and I can't remember exactly the color of the pants, but they were lighter color. They weren't like jeans, but it was that fabric.
Okay, and going back to the evidence with regards to the knife, so the knife was recovered, you said, by another officer off of Mr. Dahmer?
Yes.
But there was no forensic analysis performed.
We'd object. That's the answer to that. Asked and answered.
Why was there no forensic evidence recovered?
Same objection, Judge.
I mean, Your Honor, the physical evidence is pretty critical when you're talking about assailing somebody and cutting their hands and wrists and fingers.
I understand, however, law enforcement can only submit the evidence to forensics. They have no control over whether or not it comes back. So I don't think that this witness would have a good answer for you, Mr. Evans, regarding that specific question.
Okay. Just 1 second, Your Honor. Just going through my notes. All right, nothing further, Your Honor.
Thank you, Mr. Evans. Mr. Hunt, your opportunity to redirect.
Sorry, I want to do my best
is
to
he just
get you out
outright
of here
lying
for
at this
the
point?
day ends. So
Yeah,
I'll
straight
make
lying,
my,
man.
All right, we're gonna put you on
my
the stand. We're
question
gonna put
quite brief. So he asked you a couple questions at the start about voice identification.
Yes.
You relied on many other things other than his voice.
Yes.
I bet Your Honor leading.
Your Honor, if I actually may respond to that.
Sure.
I'm not sure the Chief Justice ruling on these matter, but there was an objection raised as a leading the other day in redirect, and the Chief Justice had stated that's redirect, and you can lead and redirect.
I would have to ask her about that.
You can, Your Honor, it's well known that you can ask leading questions and cross examination, but not direct or redirect.
All right.
It's stated in the procedural law in the state, Your Honor.
Understood. I would ask you to rephrase that. Mr. Hunt, please rephrase your question.
Sure. Okay, well, I might actually keep you here for a little longer. I apologize. You identified her, him and her, through multiple methods. Can you explain every single method?
So I was able to see Edward's hair.
And Joe, just to cut you off for a minute, I was going to get to that too. He asked you a couple questions about a helmet being on. The one thing that he didn't talk to you about, Mr. Defense Attorney here, is he actually took off that helmet at one point, right?
Yes.
Okay, sorry, keep going.
I saw his hair through it and his eye paint. I was making small conversations with them, and he acknowledged when I called him Eddie. So since he was engaging with me calling his name, I was able to positively identify him with beyond a reasonable doubt.
And then you saw him again at the dumpster.
Yes.
And then you found his clothes in the dumpster, or another officer did.
Yes.
Okay. And he asked you just about his hair a little bit, and just for my clarity, when he was seen at the dumpster, did you see anybody else in the area with his kind of orange hair?
No.
We actually are leading.
Overruled. I wouldn't call that a leading question.
And have you ever seen anybody with this kind of hair?
No.
And he talked to you a little bit about holding a bat. And he said, well, holding a bat is an assault. Just for the court's clarity, he not only held a bat, but held a bat, talked about tasting his blood, and had a pinky cut off. And his wrist was bleeding, right?
Objection, Your Honor. Is there a question here?
Sustained, Mr. Hunt.
Okay. All right. So he talked a little about holding a bat. It's not assaulting somebody. There was more to the assault, right?
Objection, Your Honor. Leading.
Please be more direct, Mr. Hunt.
Okay. All right. So I want to get this going here so you can get home. But he talked to you a little bit about a bat. You were also told that, well, you heard too, that the victim made a couple statements. What were those statements?
Sorry, say that again.
Sure. You were told earlier today, or you said earlier today, that the victim made a couple statements. What were some of the statements the victim made? Or sorry, I got the question incorrect. What were some of the statements that the two defendants made about tasting their blood?
So when I arrived on scene, they were talking about tasting each other's blood, specifically that it tasted like red soda, I think it was. They compared it to a drink of some type.
while they or Miss Killmer was holding a bat.
Yes.
And he wanted to talk to you about the law, so let's talk about the law. Was there a threat of bodily harm? That being the bat?
Yes.
Was there the ability to cause the harm?
Yes.
Right. And I don't want to talk about this too much because I don't know why he asked you, but I'll ask you anyways. He talked to you about reports. When you write a report, you don't put every single thing that happened, right? I mean, you'd be there sitting there writing it forever.
Correct.
And just one last time for clarity, I just want to go over Mr. Killmer's identification because I don't think there's any dispute that Miss Killmer did it. I don't hear them disputing any of that. So, Mr. Dahmer, you saw his hair, right?
Yes.
You heard his voice?
Yes.
You found his clothes?
Yes.
You saw his eye paint?
Yes.
What else did you see?
There was nothing else seen, but he did respond to his name.
And his name. Thank you, Sergeant. Your Honor, I have no further questions.
You, Mr. Hunt. Mr. Evans.
Yes, Your Honor. Sergeant Thompson, is there anybody else in the state that has orange hair?
His sister.
Judge, we'd object as a speculation.
I'm asking a question, as the prosecution said that his hair was unique.
Your Honor, it's speculation to know every single person has orange hair in the state.
You're okay, Sergeant Thompson. Have you ever seen anyone else in the state with orange hair?
Yes.
Yep.
And you stated that you were able to see Mr. Dahmer's hair before he took the helmet off, and you were able
Through the visor, yes.
Through the visor. The description of the helmet by most accounts was that it was completely blacked out. So, I'm confused as how you were able to see his face through the visor of a helmet, which we can submit as evidence.
Objection argumentative.
Mr. Evans.
How is it possible, Sergeant Thompson, that you were able to see Mr. Dahmer's face and possibly identify him through the helmet?
It was a black motorcycle helmet, but I could see through the visor.
Okay. I mean, I'd asked to present the actual physical helmet, but nobody's recovered it, to my understanding.
Judge, we'd object as argumentative. I think also the point that the defense attorney is leaving out is that he took off the helmet. He's just conveniently leaving out that singular point.
Okay, I'll get to that point. Sergeant Thompson, you said in your testimony earlier that when the individuals took off that you chased the female and not the male. Is that correct?
Yes.
So how is it that you saw the male take off his clothes and identify him if you were chasing the female?
I didn't see him take off his shirt and his hat or his pants, but there was a point where I did see him with a face covering that I believe was a bandana.
So you were chasing the victim in an opposite direction from the male, but yet you saw him take all of his clothing off.
That's not what I said.
Okay, can you please re-describe what you're stating then?
I did not see him take off his shirt or his pants, but at one point when I was chasing the female, I did observe him and I saw a face covering that resembled a bandana.
Okay, and just to reiterate a point, you stated earlier that simply holding a bat is not assault, correct?
Objection asked and answered.
Okay, just like I would just like to reiterate to the I would just like to reiterate then that previously Sergeant Thompson did state that holding a bat is
We'd
not
object
assault.
as the counsel's testifying.
I'm not testifying. I'm just making. I'd like the court to note specifically in Mr. Sergeant Thompson's testimony that he did previously state that holding a bat is not assault.
So noted. I do recall that.
Thank you. That's it, Your Honor. No further questions.
Thank you. Sergeant Thompson, you may be seated. Please remember you're still under oath.
Thank you.
Prosecution, do you have any other witnesses?
If I could have one moment, Judge.
Sure.
You want to?
DeAndre.
Yeah. Did you took your helmet off first? Is it were you in a position where he could see you?
No,
Okay,
I was like 2 blocks away
Your
from the
Honor, no
scene.
further witnesses. However, I would
you
like to
able
make
to,
a brief
like,
point of
put
record.
on the helmet and,
After
like, show that you can't see through
Sergeant
it?
Thompson's testimony, we would like to drop the unlawful possession charge, unlawful possession of a Class 1 firearm on Kitty Killmer. So that would
Okay.
leave her with fleeing and eluding by foot, torture and mutilation, kidnapping and assault. As she did not have the firearm, that was just Mr. Dahmer who had a firearm on him the whole time.
Understood and so noted.
Yeah, I believe that, Your Honor. I believe that might have been a clerical error when the 2 cases were merged. So
Yeah,
I appreciate the correction
see
from
that.
prosecution.
And Your Honor, the state rest.
Okay. At this point, we're going to have a brief 15-minute recess. Bio breaks, etc. We will reconvene at in 15 minutes. Thank you very much.
All right. So Kitty and Edward.
Holy moly! So much talking is happening.
Yeah. So so here's the deal, right? The Eddie is asserting that the officers are straight out lying. They don't have any physical evidence.
Yeah,
so I'm not
if
sure.
it matters, like, Kitty thinks they're lying too because Kitty didn't even know who this was when she saw him.
Yeah. So what you still want to take the stand, both of you?
Sure.
Yeah, of course. It looks super fun.
All right. So we'll call Kitty up first, and then I'm gonna go through again the basic questions. You have no record. The victim was complicit in the drinking.
Excuse me,
Hold
Mr.
on.
Sherman.
Gary, can I help you?
Did you see my text?
I did. It's the I know in previous cases they've allowed people to reference notes.
So that's because it's been submitted to the court prior. So you can get his whole testimony thrown out, and you can dismiss this case, or you can get this declared as a mistrial due to the testimony that was here.
Wow, law is so cool.
It's a bias. It's going to be a biasy. Like, there's too much bias with his testimony, so you can dismiss this. You can motion for a dismissal on this entire case.
Hey, are you able to hear me?
Yeah.
Are you sure about that? Because I've
Me
definitely seen
and
people
Cole
pull up
Gordon
notes.
both agreed.
Okay. All right.
No.
But that's off the record that Gordon agreed, of course.
No, I
but
appreciate
me
that,
and
of
him
course.
100% agreed.
Yeah, because
that-
I mean I've seen people reference notes, their phones, the MDTs and stuff.
Yeah,
and
they can do that when it's like submitted to the court. If it's not submitted in discovery, it's you're not allowed to have that.
Okay. I appreciate that.
This is Schumann.
Well, there you go. There's that.
Hell yeah. Well, yeah, they're like
What was he
totally
saying?
lying.
Yeah, and that's the other thing. Eddie's asserting that Officer Thompson. I mean, we've all seen motorcycle helmets. You cannot see through them. I don't understand
Exactly.
how.
You can just ask Kitty and she'll say that she couldn't see through anything in the helmet.
Yeah.
She doesn't know who this is at all.
Well, we're gonna try to get, if Gary's correct, and we're gonna try to get this thrown out as a mistrial. But in preparation, just in case the judge doesn't accept it, we will have to probably appeal it after the fact, just in case. But I'll have Katie. I'll have you go up on stand and testify first, and ask some basic questions with regards to the ability to identify Eddie and what you heard on the scene.
Yeah.
And how
absolutely.
far away Eddie was from you when you guys took off from each other.
For sure.
The other important part of it is going to be the fact that you didn't actually cut any wrists and didn't have the fingers, and that Mr. Williams, who's not here, was complicit in the act. Eddie, Eddie, as
They
far as
already sort of said that, so
Yeah.
that's super fun.
yeah, and then I'm also going to ask you to testify if you heard Mr. Sergeant Thompson ask Eddie any questions, and if he responded in the affirmative with his name.
Yeah, that's also a lie. They're
Yeah,
straight.
Kitty
all
didn't
their
hear
evidence is
any
lying.
name.
On top of that, I never put my clothes in the fucking dumpster, man. That was a lie. I lied to them about it. So they found random person's clothes, and they're trying to use it as evidence.
Yeah. All right. First thing we're going to do is approach the judge about the notes, and then we'll go from there.
Yeah, and then accuse them of lying to the court.
Yeah.
Boom.
Let me go grab Cyrus. Hey, Cyrus. Can I speak to you for a second here? All right. At the time of the questioning with Mr. Johnson, I wasn't aware that his notes weren't submitted in discovery, so I'm gonna request a mistrial from the judge because those notes were not submitted.
Okay.
They any notes that are utilized in courts have to be submitted as evidence in discovery. If you were aware of them and those weren't presented to me, then obviously that's.
Can someone unlock the door, please?
Okay, well, let's go inside and talk to her.
All right.
Hello, Your Honor. Your Honor?
Judge?
She appears to be in her head. We'll just request to approach the bench when she comes back.
Are you proposing to Kitty right now? Kitty is just thirsty. She doesn't really need a ring.
I'm hoping that it all works out.
We'll see. If they, I didn't realize the notes weren't submitted in discovery.
Yeah, that's a pretty big fuck up.
You seem really good at your job, sir.
Who, me?
You do. Yes.
I just like to do what's best for the citizens. Like I said, I think this is the kind of shit exactly that we talked about, Eddie. Cops just lying on the stand. I mean, that's perjury, if anything.
Right? That's what I'm saying.
I mean, I own several motorcycle helmets, and I can't see my face in a mirror, so I don't understand how Officer Thompson was able to see your face and your faceplate through the through the visor.
And even if I didn't have my hair up, the way that my hair is styled, it would be all in the back of my head, so how would he see it?
Yeah.
So, either way, and I had my hair in a bun, so it's like straight cap.
Are you going to be taking the stand?
Yeah.
If we need to, if the court doesn't, if the judge doesn't accept the motion for a mistrial because of the notes, we're gonna
Hey,
at this point at this point it'll end up being I have water. Yeah. Here you go.
Thank you so much. Thank you.
At this point, Eddie, it's gonna be again. It was always gonna be his word against yours. Mr. Johnson's testimony is circumstantial at best, but it's gonna be yours and Kitty's words against the officers. Unfortunately, the
No, that was
as
a
always,
gift.
officer testimony always weighs higher than regular citizen's testimony. Unfortunately.
Stupid, man. There's a lot of corrupt cops out here, man. It's crazy.
Yeah.
It's okay, because I know them.
Or is that just someone outside? No. Bill, Your Honor?
Your Honor?
No,
Hello?
it's not.
No? Okay.
Yeah, there's probably just someone outside knocking or something.
Man, but it's okay. It's on the ground now.
Nice.
He tried to propose. What does that even mean?
Who is
I
that?
think it means that he wants to like marry you or something.
Who is that?
This man tried to propose to Kitty.
I didn't try to propose. That's
And
a lie.
then he gave her
How
a
No,
rose
it's
bar
cap.
and then said
No,
that she's
All right,
so
sir.
No,
Sir, I
it's
need.
not she capping.
Sir, I need you to go behind the little.
I'm Kitty's emotional support checks.
That's right. You still need to be behind the.
Why does
that
she
little
not have to
fencing.
be behind the barrier?
He is
Oh,
very
she needs to as
that's
well.
true.
She needs to. If you need to speak to loved ones or whatnot, you need to be behind the fence. I'm sorry.
Oh, he's not a loved
Okay.
one.
I just snitched on her. My bad. Shit. Hey, that's my bad. I didn't mean to snitch on you. I just snitched on you. That's my bad. I ain't no snitch.
What?
Wow, that guy is totally a snitch.
I mean, you
We
kind of
should
just
kill
did,
him.
so.
What? Really? You think so? But he's
Yeah.
a friend.
Yeah, people say they're your friends a lot. And then they kill you.
Huh, Kitty never experienced that before, but maybe. Don't kill Kitty!
What?
Don't kill Kitty, please!
I was gonna kill Kitty, bro.
Please don't kill Kitty, please!
I'm not. Wait. Why?
Please! Kitty doesn't want to be killed today,
Why?
please!
Don't kill her!
Trey.
Yeah.
Please don't kill Kitty!
So I went over to speak to my friend Junior, who's sitting in the gallery.
Yeah.
And I overheard. Hold on.
What's going on here?
Can I just
Hey,
have a
sir,
moment?
can you please? I'm
Yeah,
gonna have to.
You're gonna have to. Yeah. And I overheard Cyrus speaking with Gordon and Schumann, and the words I heard was, "Should we file a bar complaint?"
Against who? Me? Or
I don't.
Schumann?
That's what I didn't. No. If it's against you, I'm going to be fucking furious because I went over there and Junior spoke to me as someone else in their group because Cyrus didn't realize he was talking quite loud. Okay, my friend Junior has got the bright red hair and the suit.
Yeah.
Sitting on the second aisle, so that's where how far I was, and I could hear Gordon, Schumann, and Hunt, and all I heard was, "Should we file a bar complaint?" Because we could, from Cyrus Hunt. And then it was whoever spoke next, whether it was Gordon or Schumann, I couldn't hear because Junior spoke to me.
That's fine. One bar complaint's not gonna do anything. If I can get my clients off, then fuck it. They broke the law.
Yeah.
They broke court procedure. Then it is what it is. I didn't ask.
Yeah.
I didn't ask Gary to come up to me. So, if
That-
anything, the bar complaint should be against Gary.
That's made my blood boil. I actually feel like emailing Williams, and she was sitting here with them in the beginning, but left. That's why, like Travis, I said to Travis, "Can Schumann actually do that? Can he actually do that?" And then Travis said to me that, "Well, you can have conversations with people in the recesses all you like." I said, "But he was walking over to someone who wants him to work for his fucking firm." Because I believe, like, okay, listen, so I didn't say anything else other than, I mean, when Schumann called me that morning, you know that I knew exactly what he was doing, right?
Yeah.
When he called
Yeah.
me. So, and Travis has got his mind on 1,000 other things anyway. But,
Yeah.
I swear to God, if I see complaint against you,
I mean, it's one complaint. What is it like? You need how many complaints do you need to get a actual effective strikes against your fucking your bargain license?
just depends on the outcome.
Yeah. Let's go see what these are.
Judge? Your Honor?
Your Honor?
Hello. Yes.
Oh, wait.
Defense has a motion.
Your Honor, I was not aware that the notes that Mr. Johnson utilized were not submitted to the court and as evidence, so I'd like to move for a mistrial.
One moment. Which notes are you referring to?
Mr. Johnson kept referring to notes during his testimony and cross-exam, and those notes were not submitted as evidence during the discovery period.
I can respond if you like.
Yes, please.
Okay, so as for the notes, first of all, they weren't relied on multiple times. Actually, I recall one time where he said, "Can I look at my notes?" I said, "Sure." And there was no objection from the defense at the time. They raised no cause for concern, and I believe that they didn't properly table the objection for them to now ask for a mistrial. Had they objected to it at the time and that objection had been overruled, well, then I think that they could come back here and make an argument about how there should be a mistrial, even though it really shouldn't, because it's not grounds for mistrial. But that they could try and make grounds for a mistrial on those grounds. However, they didn't preserve that objection. They didn't table the objection. Matter of fact, they didn't make the objection, and they knew that he was referring to his notes because he had asked to refer to his notes, and nobody made any objection.
I
think this is
whether
a way of
anybody
them
made the
kicking
objection
the
or-
can down the road, and now that I don't know, maybe they think that I don't know, maybe they think that they're behind or
Your Honor,
behind
whether
in the race or
anybody
something
makes
in that
an-
regard. So maybe now that's why they're bringing up this motion, but they didn't make the motion at the time, and I don't believe this is grounds for mistrial whatsoever.
Your Honor, regardless of whether an objection was made at the time, it's still a violation of evidentiary procedure.
Oh, Your Honor,
For
it's
my-
very unclear as to what notes anyone's
And
referring
and
to,
and
or
for the
whether or not
record,
this was
and for the
submitted on
record,
docket, or as to whether or not these are
and for the
actual
record,
notes that were submitted.
and for the record, he referred to his notes several times, not just once, at least 3 times in my cross exam alone.
From my understanding, the witness was referring to personal notes of like a journaling nature.
There still have to be any notes, any evidence used in or notes used in the proceedings have to be submitted as evidence, Your Honor.
Yeah, he was using them for the purpose of recalling the incidents at hand. We weren't submitting his.
He was referring to a physical document,
We weren't
Your Honor.
submitting his journal as evidence, Judge. I mean, that's that's insane. Well, why would we submit his journal, his personal journal, as evidence? And if
you
we
saw him
submit,
pulling notes,
if
Your
we
Honor.
wanted to submit certain portions of his journal, we'd have to admit the whole thing. And I don't know about you, but that doesn't seem right to admit somebody's whole journal. He used it to refer to an incident that had happened. And truthfully, I really don't see the big
Whether
issue
it's his
here. And they
personal
didn't
journal
make
or
an
not, Your
objection
Honor, it's
at
still
the
part of the
time.
evidentiary procedure.
His journal as
If he's utilizing it as evidence and part of his testimony in the court, Your Honor, it's part of the evidentiary procedure. It has to be submitted as evidence and be disclosed to both parties.
I would disagree with you, Mr. Evans. If the journal was submitted as evidence, it would be hearsay.
How would it be? Excuse me?
It would be the witness's recollection. It would be no different from a statement.
And statements have to be entered as evidence, Your Honor.
Regardless, he was here as a live witness rather than having entered a statement. I see no difference between written notes being referred to by the witness on the stand and submitted as a written statement.
Your Honor, this is a direct
Thank you,
violation
Your
of
Honor.
evidentiary procedures as stated in the state bylaws.
Will you refer me to specifically what you are looking at?
I will pull it up.
If you had asked me to enter
I wasn't made aware
Mr.
at the
Johnson's
I wasn't made
journal
aware at the
into
time
evidence, I
that they
would have
weren't entered.
denied it.
I was not aware at the time that those notes were not entered as evidence, Your Honor.
You know, just to make sure we're on the record, just in case this does go to an appeal, the reason why he knows is because a former prosecutor on the case approached him and had informed him about details of the case.
Who is he that you're referring to?
Gary Schumann. We're not looking
Okay.
to do anything or have anything done, but I would just like that on the record that that's the reason why he waited, because he didn't. I assume the defense attorney didn't think it was objectionable at the time, and because it really isn't. I mean,
It is objectionable. I wasn't aware that the notes were not entered as evidence at the time, Your Honor. And whether they
All of the evidence that is entered is on the docket.
where that information came from is irrelevant because it's not privileged information or anything. I mean, he
Sorry,
simply
No, it's
pointed it
the
out.
witness's testimony that he is giving to you on the stand.
No, I'm talking about the Mr. Schumann approaching me during the recess, Your Honor.
Sorry, just so I can understand, where does it say that they can't refer to notes?
I'm pulling up the website now. Production of documents at trials. Document evidence was presented to prove disprove certain allegations at trial. These
Sorry, can you
documents
just say
be
where it is?
Sorry,
rather than-
it's in the evidence and exhibits under court procedures.
Okay, and where is it in here?
Documentary evidence. And
the bullet point?
Yeah. His notes should have been submitted as documentary evidence.
I disagree. And I disagree for this reason. A witness may refer to notes. He did specify that he was looking at his notes to refresh his memory at that time, as Mr. Hunt has said, and I agree. There was no objection to the witness referring to these notes to refresh his memory for his sworn testimony. I would disagree that any notes a witness may have or refer to at any time need to be entered into evidence. If you choose to file an appeal after this matter is over, you may do so. But at this time, I am going to deny your motion for a mistrial. And I disagree with a witness's notes or journals or anything of the sort that may be referred to after having asked permission to the necessary of that being entered into evidence beforehand.
That's fine.
Thank you, Judge.
We'll appeal the decision. That's fine.
Okay.
Thank you,
Let's
Your Honor.
proceed. We're already 5 minutes over time.
Okay.
Getting famous is so easy.
The judge isn't accepting the motion, so we're gonna proceed.
Oh, okay.
Okay.
Really? That's kind of weird. Okay.
Yeah, don't worry. We'll appeal the decision at the fact.
All rise, the
we'll
court is
probably
now back in
we'll
session.
probably win an appeal, but we'll see.
All right.
Listen, sir, get out of here.
Yeah, that dude's really weird. I don't like him.
You may be seated. We left off with the conclusion of the prosecution. Defense, do you have any witnesses?
Yes, Your Honor. The defense would like to have Miss Kitty Killmer take the stand first, please.
Hello. Just kidding, over here.
Yep, just stand in front of the bailiff.
Hello, Mr.
Hello, can I get you to raise your left hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may be seated, Your Honor. The witness is sworn in.
Thank you, Mr.
Good evening, Miss Killmer.
Hello, Mr. Lawyer Man.
Miss Killmer, can you please state your full name for the record?
This is Kitty Killmer.
And Miss Killmer, on the date in question, how many days had you been in the city?
Like a week, maybe.
In that time and since, did you have any charges or any arrests on your record?
Nope-sies.
Okay. Can you please describe the interaction with the alleged victim on the date in question?
Everything, like, from the beginning.
No, just I'm sorry. Let me specify. When you arrived at the cemetery with the alleged victim, can you please describe the relationship to the alleged victim on the scene at the cemetery?
Kitty is confused. What relationship? She doesn't have any.
Okay. Do you let me rephrase. Did you meet the alleged victim on the day of the alleged incident?
Yes, sir.
And when in the description of the drinking of the blood, was the victim complicit in the activity?
He was super duper excited to do it. He wanted to drink the other person's blood too.
And did he in fact drink yours or the other? Did he drink your blood or anyone else's blood?
Yeah, he drank the other person's blood.
Okay, and then when the police officers arrived on scene, can you describe his reaction?
Kitty doesn't remember his reaction to the police.
Okay. With regards to okay, so when Officer Sergeant Thompson arrived on the scene, did you hear him speaking to the other individual with the motorcycle helmet?
Kitty remembers the officer there, but Kitty doesn't remember what was spoken about.
Okay. Did you hear anyone's name called?
Nope.
And prior to the court docket being posted, had you ever heard of Mr. Dahmer in your time in the city?
No, Kitty doesn't know who that is.
And at the time on scene, what was the other individual, male individual, wearing?
He was in all black, and he had a black helmet with a super duper black visor. Kitty could not see him at all.
So, do you see the individual that you saw at the cemetery in this courthouse?
No.
And when the cops arrived, were you what was your state of mind?
is always super duper happy and excited all the time. Because there's always friends to be made everywhere.
And did you feel like the alleged victim was at the time friendly?
Yeah, he said he wanted to be super duper friends.
And when the police officer described you and the other individual fleeing from the scene, were you able to maintain visual contact with the other individual?
No, he totally ran away. Kitty was sad.
What direction would you say he ran with reference to your own position?
Kitty stayed inside the cemetery and he ran away outside the cemetery.
And did you assault the victim, the alleged victim, in any way?
Nope.
Did you have any besides the baseball bat, which was in your hands? Did you have any other weapons on you in any of any kind?
Nope-sies.
Did you ever utilize the baseball bat in any manner with the victim?
No, that's just Kitty's toy.
Okay, no further questions, Your Honor.
Thank you, Mr. Evans. Mr. Hunt.
Good afternoon, Miss Killmer.
Hello, Mr. Glasses Man.
How are you doing today, ma'am?
Super duper good. This
Okay.
is so fun.
Okay. Why is it fun?
Kitty's never been in the law before.
Okay. So you said after this incident occurred, and it occurred on the 30th, right?
Sure, maybe.
You've been in the city for about a week, is what you testified to?
Kitty thinks so, yeah, in that big city.
Okay, and then you said this was your first time getting arrested?
Yeah, Kitty never got anything before.
Okay. And on the 2nd of October, did you buy a pistol MK2?
Kitty does not know what that is.
Okay. Did you buy a pistol on October the 2nd?
Objection and irrelevance.
Your Honor, it's going to impeach the witness as she bought a weapon at the start of the month, and that's much longer than a week before the incident occurred.
Proceed, Mr. Hunt.
Did you buy a pistol on October the 2nd?
Kitty doesn't remember.
You don't remember? Were you arrested on October the 2nd for evading arrest?
Kitty does not remember.
Do you recall getting arrested on the 29th of October for robbing a store?
Kitty does not remember that.
Do you recall getting arrested for robbery with Jackson Moss on October the 11th?
Jax!
Hey,
You
yo,
do
they said my
recall?
name.
Kitty knows Jax. Hi, Jax.
Hey,
Do you
Kitty,
recall
what's
getting
good?
arrested, ma'am?
Oh, no, Kitty was doing a blog.
But you got arrested, did you not?
Kitty talked to police. Is that being arrested?
And did Kitty go to the cells of the police station?
Maybe.
You don't recall?
No, not really.
So it's fair to say
This
that
is
you don't
not
really
helping
recall
at all.
a lot. You don't recall the last 3 times you were arrested, right?
Kitty doesn't recall a lot.
Fair to say you don't have that good of a memory.
No, not really true.
So when I asked you, and when your lawyer asked you a little bit ago, this is your first time being arrested, that was a lie, was it not?
Kitty didn't remember.
You didn't remember. Let's see if we can refresh your memory. On the 2nd of October at around 7:24, so I presume a little bit before, you were arrested for evading arrest on Sonora Freeway. Do you recall?
No, but Kitty believes you if you said it's true.
Okay. And on October the 4th, you were arrested for robbing a store near El Rancho. Do you remember that?
No, but Kitty believes you.
And on the 10th of October, you were arrested for, again, robbery with Jackson Moss. Is that correct?
Objection, Your Honor. Does the prosecutor have a point with all the questions?
Yes, Your Honor. It goes to the fact that she's lied on the stand.
Gentleman clapping in the gallery, please remove yourself. That was not a request. Continue, Mr.
Yeah,
Hunt.
that guy's stupid.
Thank you, Judge. So it's fair to say that you don't have the best memory. Is that a fair statement?
No, why is that a fair statement?
Objection, Your Honor, inflammatory. Objection, Your Honor, inflammatory.
Would you rephrase the question, Mr. Hunt?
It's fair to say that the incidents that I've just mentioned to you, the 3 times that you were arrested before this incident, you don't recall any of them, right?
Yeah, Kitty doesn't remember those.
Okay, but you remember this one.
Of course, this is a big court law thing.
All right, so let's talk about this incident a little bit. So you talk a little bit about the victim. Tell me more about the victim and how his pinky got cut off.
What do you mean, mister?
Do you recall hearing testimony that his pinky was cut off? Or he lost his pinky? You do recall that testimony?
Yeah, someone that said something about that, yeah.
Okay. So how did that come about happening? His pinky being cut off? You said he did it willingly?
There was yeah, so he was super duper excited.
Objection, Your Honor, speculation.
Oh, okay.
Mr. Hunt?
I don't understand how it's speculation when she did it and she's about to testify what she
Your
did.
Honor, Your Honor, you can't. There's no evidence to prove that either of the my clients cut off the alleged victim's finger, Your Honor.
And it has been witness
So it's
testimony.
speculation.
That's why I'm questioning the witness on the incident.
You just told her that she cut off the victim's finger, sir.
Could you rephrase your question, Mr. Hunt?
Did you cut off the victim's finger?
Nope.
Okay, who did?
The other person.
The other person with you did?
Yes, sir.
And you were there with them?
Yeah.
Okay. Can you describe how his finger was cut off?
With a knife? What?
Okay.
Kitty is
With a knife, you
confused.
said?
Yeah.
Okay. And you ran from the police. Is that an accurate statement?
Yeah.
Okay. And you held a bat towards the victim while you two were talking about tasting each other's blood, right?
Kitty had a bat.
Right. And you were holding it near the victim, correct?
Kitty was holding a bat.
Okay. I'd like to talk a little bit about how you actually got the victim. Where did you get the victim from?
Kitty doesn't remember exactly where.
You don't remember?
No, not exactly where.
Is it fair to say that you kind of threw him into the trunk?
Kitty didn't throw anyone into the trunk.
Oh, sorry.
Objection, Your Honor,
did Mr.
speculation.
Dahmer?
Objection, Your Honor, speculation.
Mr.
It's Dahmer.
Your Honor, we don't know if it's speculation because the witness isn't being given the opportunity to ask. I think the correct remedy would be only answer if you know.
Fair. So noted.
That doesn't preclude you from prosecution asking questions that are speculation.
Okay, so you saw him go into the trunk. Your friend did that, right?
Sorry, what? Kitty is super confused. You're using lots of words.
Your friend put him into the trunk, right?
Objection, Your Honor, assumption.
Kitty doesn't remember.
That
Okay.
was that will be sustained. Please rephrase, Mr. Hunt.
All right, Ms. Killmer, what do you actually remember
About what?
about the incident?
What about the incident?
So let's break it down. So you were in a stolen car, right?
Kitty has no idea.
Okay. And that car, were you driving the car, or was Mr. Dahmer driving the car?
Kitty wasn't driving the car, someone else was.
So Mr. Dahmer was
Objection,
driving the
speculation,
car.
Your Honor. Mr. Dahmer has not been confirmed to be at the scene at all.
Sustained.
So when you got to the graveyard, what was your intention at that point?
Kitty has no idea to make friends.
Okay. And who was the person that was with you? What was their name?
Which person? Kitty doesn't know either of their names.
You don't know either of the people that were with you,
No, of course not.
but you do recall what they look like?
No. Kitty knows kinda what the one dude looked like who lost his finger.
Okay, but you don't recall who the person that was with you. You don't recall what he looked like.
Kitty already described him. All black, couldn't see him. Really, really black, black, black.
Okay. So you're not really saying here today that it wasn't Mr. Dahmer. Is that correct?
Kitty
'Cause he
is
was
confused
wearing all
by
black.
that.
Objection, Your Honor. Speculation.
Judge, I'm asking her to clarify her testimony because I think it's quite clear that she actually can't say whether or not Mr. Dahmer was there from her testimony that she just gave.
Your Honor, the prosecution is clearly asking a question to guess an answer. She's already stated she doesn't know. There's no physical evidence. He continues to ask speculative questions.
Sustained. If you're going to clarify, please make it more clear.
I'd like to clarify an answer to your question. You don't know whether or not Mr. Dahmer was with you, right? That's what you're
Objection, Your Honor.
testifying to.
Argumentative. That's not a question.
I disagree.
Sustained. Yeah. Rephrase one more time, Mr. Hunt.
Okay, so let's just break it down piece by piece. So you drove to the graveyard, right? Or your friend, Mr. Dahmer, drove to the graveyard?
Again,
and you were in the car
objection,
with him?
speculation, Your Honor. Mr. Dahmer has not been positively identified on site. He keeps referring to my client,
I
and it's
disagree, Judge.
prejudicial at best.
He was seen on the scene by an officer who testified to that, who knows him from previous experience. I don't
Your-
think
Your
there's
Honor,
any doubt that
Your Honor, can
Mr.
we,
Dahmer was
can
on
we,
the scene.
can we have a sidebar, please?
Yes.
Your Honor, I believe the proper question is to whether or not the witness knows who this other individual is, not as to whether or not they have been discerned as Mr. Dahmer. The witness doesn't know that it's Mr. Dahmer. That's one thing, but overall, the testimony tends to show that it was.
Yeah, but Mr. Hunt continues to reference my client's name in the line of questioning, asserting that he was there. The whole point of this trial
Because he
is to
was
assert-
there.
That's
I
the court.
would-
That's for the court to decide, sir.
For the purposes of questioning, please refer to the other suspect as I don't know, not by name.
The whole point.
Suspect
The whole
two, the
point of
male
this trial is to whether to find this individual guilty or not guilty of being present.
I'm
you
trying
can't keep.
to impeach the witness. The reason why I'm asking these questions, because quite frankly, it's quite obvious that he was on the scene. So I'm going to get it out.
Quite
of her
obvious
that
to
he
who?
was.
This is the whole point of having a trial, is to ascertain whether my clients are guilty or not guilty. You are already prosecuting him as being guilty by continuing to reference him as the individual on site.
Because I believe through the evidence that's been established that he has been identified to be
It's
on
not
the
your
scene.
it's not your place to determine my client's
that's
innocence.
up to me. Please, just if you're going to refer to the other individual or the other suspect, you can refer to them as the male suspect.
Okay. And at what point am I allowed to actually impeach the witness? Because at one point, I believe that she's lying, and I'd like to get out of her, and I'm not going to be able to get to the fact that she's lying unless I'm able to actually inquire about it. Is my issue here?
You can inquire to her without
was
referencing the
asking
other
the
client
judge.
by name.
Well, I'm saying I'm not going to be able to have her identify who was with her unless I'm actually able to inquire about who was with her, and I'm
You're
not
on-
being allowed to do that.
Respectfully, Your Honor, the client on the stand has already said that she does not know Mr. Dahmer, has never met him before the docket was posted.
And I
That's
believe
been
she's
asked and
lying,
answered.
Judge. That's why I'm trying to impeach her on that fact.
It's been asked and answered, Your Honor. She doesn't know who the other individual was. She stated it multiple times now.
Yeah. I think there is enough, Mr. Hunt. If there is enough for you to impeach this witness. Should you choose to, with what has already been asked and answered, if that's the route that you're going. There are ways to question the witness on the stand regarding the events of the day without continuing to refer to Mr. Dahmer as having been on the scene definitively. I would advise you to expand your how am I going to phrase this? Realm of questioning, I suppose. Does that make sense?
Sure.
Mr. Evans?
That's fine, as long as he does not continue to reference my client as being a guilty individual, which has already been stated that this is the whole point of the trial.
Please continue to refer to the male suspect as the male suspect. Should Mr. Dahmer take the stand, that's a different kettle of fish.
Understood.
All right.
Okay.
You good?
Thank you. Excuse me.
All right, Miss Killmer.
Hello, Mr. Glasses Man.
Okay, so I want to break down the incident, and I'll ask you a couple questions about the incident itself. So I just want to break it down, go through all the incidents that happened in the correct order, and then we'll go from there. So you got to the graveyard, right?
Yeah.
You hopped out of a car with a male suspect, right?
Uh-huh.
And then one of you took out somebody out the trunk, right?
Yeah.
And then you spoke to the victim about tasting each other's blood, right?
Uh-huh.
And then after you talked about talking about tasting each other's blood, a police officer came at one point, correct?
Uh-huh, after.
And when the police officer came, he broke you up from the victim, correct?
Yeah, I suppose so.
And when he broke you up, he started going towards the victim, is that right?
Kitty doesn't remember.
And then when he went back towards the victim, you started running, and so did the other male, right?
Kitty doesn't know if that's how it happened.
I'm sorry? You speak up?
Kitty... Oh. Can you hear Kitty okay?
Yeah, it's okay. Speak into the mic.
Can you hear Kitty okay?
It's okay. What did you say, ma'am?
Kitty doesn't know if that's how it happened.
Okay.
In that order.
So you ran away at some point, correct?
Yes.
And then you continued to run with this male, right?
Asked and answered, Your Honor.
I never asked that question.
I asked it, Your Honor.
Sustained. Move on, please.
After you started running, you two broke up, correct?
Uh-huh.
And at one point, you jumped over a fence, right?
Yeah.
And then at that point, you saw a male looking like Mr. Dahmer running as well, right?
It's
Wait,
Dahmer,
when?
man. Come
Dahmer,
on.
sorry.
What? Kitty's confused. Wait, when?
So when you were running, at one point, you met back up with a person, right? You saw him running as well?
No.
You didn't see
Kitty
that?
didn't see someone running.
Okay. And then at one point, you were taken down and you were taken into custody?
Yeah.
Okay. And after you were taken into custody, you were searched?
Uh-huh.
You were taken to MRPD?
Yeah.
And then you were sentenced, right? You pled not guilty?
Uh-huh.
Okay, so now that we have all that in order, I want to talk to you about, I want you to actually explain this. Explain everything leading up to this event. So explain where you got this person from.
Oh, right now?
Yep.
Oh, Kitty doesn't know from where. Just saw him.
Just saw him? And you weren't driving the car at that time, right?
No.
Okay, and how did you actually get into the car with this other person?
What? How did Kitty get in the car?
Yeah, with the other male.
Oh, someone held a gun up to her and said, "Get in the trunk."
I'm sorry, not not the victim. You got in the car with the other male who eventually he cut the person's pinky finger.
Yeah, that's what happened. Someone held a gun up to Kitty and said, "Get in the trunk."
Oh, okay, I see. So he told you to get in the trunk.
Yeah.
Okay, and at one point you got out, and then you got into the passenger seat, I presume.
Yeah, eventually Kitty was in the passenger seat.
And why did you make that switch?
Because Kitty made a new friend.
Okay. And how did you get out of the trunk?
She got out. Someone let her out of the trunk.
And who let her out of the trunk?
Someone with all black clothing.
And what did that person sound like?
He had a voice.
Sure. And it's fair to say that Mr. Dahmer, have you spoken to him since this incident occurred?
What, since the arrest?
Mm-hmm.
Yeah, Kitty spoke to him today.
Okay. What did you talk to him about?
Objection, objection, Your Honor. Relevance. Are we going to describe what we had for lunch as well?
Your Honor, it's communication between the two defendants. I believe it's perfectly relevant to the case.
Proceed.
Yeah.
Okay. Kitty was talking to him about all the super famous people in the city, like Jax and the lawyers and everyone that's super duper famous in her blog.
Okay. And eventually you came here. What I'm failing to understand is, I'm not asking the argument. I was curious. You're saying that you don't know this person here, right?
Asked and answered, Your Honor.
Really.
Objection.
And why are you here with him? Why didn't you ask to be tried separately?
Kitty was told to be here.
Objection.
Kitty is confused about that question.
Your Honor.
Okay. And
Your Honor, can I approach the bench?
just
Can we approach the bench, please?
Yes. Come on.
For the record, the individuals were supposed to be tried separately. The request to have the cases joined was made by, I believe, by the previous prosecutor. If you look at the docket, they were to be tried separately.
I recall.
So this was not the.
Yeah, I can move on. I don't need to. We don't need to go over this for 5 minutes. It's not a big deal.
All right.
Okay.
Okay. I do have a question for you. Oh, sorry. Wait for the chat. Who? So you said earlier that you were drinking blood, right? You guys want to taste each other's blood,
Uh-huh.
and
Objection, Your Honor.
you eventually did that.
Inflammatory.
Judge, it's not. Sorry, I'll leave it to discretion of the court.
He's referring to statements within the docket. I would call that relevant to the case.
All right, well,
Proceed,
then,
Mr. Hunt.
Asked and answered, then, Your Honor.
All right, sustained. If you have a route for this, Mr. Hunt, please make it evident.
I am judge, but I have to establish foundation. Okay. Who was drinking the blood?
Everybody.
Everybody,
Uh-huh.
including Mr. Dahmer.
Objection.
I'm
Your
sorry.
Honor.
I'm sorry. The male.
It's Dahmer, man.
Dahmer.
No, I wasn't even there, so no.
The other male he was drinking the blood as well, right?
The person that in the black, yeah.
Okay. And who had the idea of drinking the blood?
The person wearing the black.
So the person in the black had the idea to start drinking blood.
Yeah.
Okay. And then you guys all started doing. You kind of just tagged along.
Yeah. He made it sound super fun and delicious. So.
Okay. I gotta have one moment, Judge. Sorry. Are you referring to the male?
The person dressed in black.
Right. So not the victim. The other
Oh.
person that was with you.
Wait, what are you asking specifically about?
So you're saying there was a person there. He was talking about drinking blood. That was the other person that was with you. The guy in the all black that we don't know who is apparently.
Oh, the person that had the first idea.
Right. Okay. Sorry, just if I could have one moment.
How is this guy saying supposedly and making all
Wow,
these
Kitty has
accusations
never
at me?
answered
It's
so
really
many questions
stupid.
before.
This lawyer's making a lot of accusations.
Yeah.
It's really annoying.
Yeah, I've already had, that's what the sidebars were about. He keeps referencing you by name, and if he does one more time, I'm gonna request a mistrial.
Yeah, it's stupid, man. He
Yeah.
like keeps on trying to allude that it was me there.
Yep. Trust me, if he does it one more time, we're gonna have another sidebar.
Alrighty, hell yeah.
All right, I do have a couple questions for you. Very nice to meet you. My name's Oliver Hall. Miss Killmer.
Hello.
Hey there. All right. Now you stated you participated in the drinking of blood, right?
Asked and answered, Your Honor.
Wow, okay.
Objection, Your Honor. I said asked and answered.
Clarification.
Sustained. If you're going to clarify, please make it evident.
Okay. For the purposes of clarification, did you drink blood?
Yeah.
Whose blood did you drink?
Kitty doesn't remember his name.
Okay. Can you describe him? Was it the victim? Was it this other individual in black?
Kitty thinks it's the person that you're saying is the victim.
Okay, so you drank the victim's blood.
Yeah.
Okay. And how did you get access to the victim's blood?
From his vein.
Okay. Can you describe the process in which you extracted the blood from his vein?
Kitty didn't do that part.
Okay.
So no.
Describe how it was extracted then.
With a knife.
Okay. Who did so?
There was a person wearing black. Kitty already said that.
Okay. And that person stabbed the victim's wrist, right?
Stabbed.
Well, I'm asking you. Did they stab him? Did they slit the wrist? How did they extract the blood from this wrist?
Kitty would say he cut the wrist for the blood.
Okay. And how did you drink the blood from the person's wrist? Did you pour it in a cup? Did you lick it
Objection,
from
Your
their
Honor.
arm?
Relevance.
Your Honor, I can respond if you'd like, but it is highly relevant as to how blood was extracted from a victim and how this witness.
The victim has already
drank that
stated how the blood was extracted. Whether it was in a cup or a vessel or a tub is irrelevant, Your Honor.
Yes, Your Honor. How she actually consumed the blood is highly relevant.
I would agree. Overruled. Continue, Mr. Hall.
Do you need me to repeat the question for you?
Yes, please. Thank you, mister.
All right. How did you actually end up consuming the blood?
From a glass thingy.
Okay. And where is that glass thing today?
No idea.
Okay. Was that yours or was that another person's?
It was not Kitty's.
Okay. And when you were drinking the victim's blood, you didn't have a license to possess his blood, right?
No idea what that even means.
Okay. You don't have a medical license, right?
No, Kitty doesn't think so.
You're not a nurse or anything, right?
No, not as far as Kitty knows.
Not a medic?
No.
All right. So you don't have the lawful authority to drain someone of their blood. Is that fair to say?
Kitty doesn't know anything about the law.
You'd agree that you need a license to draw someone's blood, right?
Kitty has literally
Objection,
no
Your
idea.
Argumentative.
Yeah, I throw this out that's argumentative.
What the fuck this is supposed to...
Get to the point, Mr. Hall.
Of course. Just give me one moment, all right? All right, and just to clarify, this individual in the black, he also partook in the drinking of blood, right?
Sure.
Asked and answered, Your Honor.
Just that was for clarity.
Understood.
Okay. I think that's it for now, Your Honor. Let me just see if the other counsels have anything. All right, no further questions for this witness, Your Honor.
Thank you. Your opportunity to redirect, Mr. Evans.
Yes, Your Honor. Ms. Killmer, to clarify,
Hello.
are you able to identify the individual in black in this courtroom?
Objection, asked and answered.
I said to clarify, Your Honor.
Sure. Go ahead.
We'd
Ms.
object
Killmer,
as the leading judge.
Ms. Killmer, To clarify, are you able to identify the individual in black?
Nope.
And with regards to the victim, to clarify, the alleged victim partook willingly in the activities.
We'd object as the leading judge.
Yeah. Well,
To clarify, Miss Killmer, has that leading? It's a direct question, Your Honor.
It's a question that
all
gets
right,
a yes or
Miss
no
Killmer,
answer.
Miss
That's
Killmer,
what he's
did
been
the
objecting to
Miss,
this whole proceeding when I've asked the question.
Miss Killmer did.
please rephrase.
Miss Killmer, did the alleged victim willingly partake in the blood drinking?
Yeah.
That's no further, Your Honor.
Recross, Mr. Hunt.
Yeah. Just to confirm, to clarify, the person who had the idea to drink the blood was the person in the black, correct?
Uh-huh.
Nothing further, Judge.
You may be seated, Ms. Killmer. Please remember you're still under oath.
Thank you, Miss Honor, Your Honor, Miss.
Defense, do you have another witness?
1 second, Your Honor. All right, you still want to take the stand?
Yeah.
All right, let's do it.
Alrighty.
Your Honor, the defense calls Mr. Edward Dahmer to the stand.
So if you can raise your left hand, please.
There
Do you
we
swear to tell
go.
the truth, the whole truth, and nothing but the truth?
Yeah, swear on my mama, gang member.
Okay, you may be seated, Your Honor. The witness is sworn in.
Woo.
Thank you.
Mr. Dahmer, can you state your full name for the record, please?
Yeah, it's Edward Dahmer. No middle name.
Mr. Dahmer, the night in question, were you present at the alleged crime?
No.
And where were you located, sir?
I was at the Cockatoos. There was a Cockatoos event that night, man.
And what were you wearing that evening, sir?
I'm not sure. I have a lot of clothes.
Mr. Dahmer, prior to the court docket being posted and you being arrested, had you ever met Miss Killmer before?
No, I don't even know who she is.
And when they the items that they allegedly found in the dumpster, do they belong to you, sir?
No.
Had you ever seen the items that they described before?
No.
Objection, Your Honor. I'd call to strike the last two questions. If the witness has not seen the items, how could he know as to whether or not they're his?
Because they were posted in the docket, Your Honor, and they were described in court.
True.
Fair. Proceed, Mr. Evans.
Thank you. Excuse me. Thank you, Your Honor. Mr. Dahmer, are you at any point were you anywhere near the cemetery?
No. Nowhere near it, man.
No further questions, Your Honor.
Thank you, Mr. Evans. Mr. Hunt, your opportunity to cross-examine the witness.
All right, sorry, you kept correcting me on your name. What's your name? Or how do you pronounce your last name?
Edward Dahmer.
Dahmer. Okay. Mr. Dahmer, I'm going to do my best to keep this quite short. I think if there's anything we all have in common here is we want to get out of this courthouse. So I'll make it quite brief. Have you ever drank someone's blood before?
Nah, man.
Have you been 5150 before?
Yeah.
What was the 5150 for?
You know, I was going through a rough time with me and my sister. And, you know, we, tried to hatchet some lady because we thought she was our abusive mother.
Okay. I'm just going to refer to something here quickly. And while I'm taking a look at this, so you were found near a trash can, right?
I'm sorry, what was the question?
You were found at a trash can when law enforcement located you?
True.
Okay, and your clothes were inside of that trash can?
No.
Okay, those weren't your clothes?
No.
Asked and answered, Your Honor.
Sustained. My fun, Mr. Hunt.
And so you said you were at Cockatoos, but one thing I understand, that place is nowhere near Cockatoos where you were. Explain that to me.
True. That was earlier that day. I'm just saying, like, what I remember doing.
Okay. So when you said earlier today that you're coming back from Cockatoos, that was a lie.
No, it wasn't a lie. It's probably earlier in the day.
Right. So
oh, no, man.
while you
There's
were
a lot of days. I can't remember what I do every day and exactly how it goes.
While you were 5150, did you drink someone's blood?
No.
You don't recall drinking someone's blood at Parsons?
No.
Asked and answered, Your Honor.
Judge, we'd asked to admit rebuttal evidence. It's incident report 9306 that states, while at Parsons, Edward bit and drank someone else's blood at the facility. We'd ask that this be used as impeachment evidence and rebuttal evidence.
Accepted.
So I'm going to refer here to incident report 903. You do recall being at Parsons, correct?
True. Kind of. Yeah.
And
It's in a really rough place, man.
Sure. And it states on this report, while at Parsons, Edward bit and drank someone else's blood at the facility. Are they lying? Is that not true?
I'm not sure, man. You know, it's going through a lot of the time. Can't really recall. Was also going through my ketamine withdrawals.
Okay, but you're not
Objection, Your Honor.
disputing that it didn't
This line of
happen.
questioning is inflammatory. Mr. Hunt is reading off of a police report. So
Your Honor, it goes to a common MO. Ms. Killmer had established in her testimony that Mr. Dahmer, apologize, the male suspect
Dahmer
was the individual who decided to get the idea to drink the blood, and Mr. Dahmer has an experience of drinking people's blood, and it goes to a common MO that he has.
Mr. Dahmer has already testified that he was not on scene, Your Honor.
True.
And he's lying.
Objection, Your Honor.
That is your job to prove to the court, Mr. Hunt. Also, Mr. Hunt, could you please provide the rebuttal evidence to the court docket so that
Sure.
Mr. Evans can review what it is that you're referring to?
Sure, I can do that now. All right, I have filed it to the docket, Judge.
Thank you.
Okay, so back to it, Mr. Dahmer. Dahmer, sorry. Okay, so let's see what it says in this report. So it states in the report, and I quote, "They continue to say that they drank each other's urine and continued on the same topics throughout transporting. Once at Mount Zona, they continued to say that they wanted to drink blood and want to have ketamine."
Objection, Your Honor. Is there a question here?
I haven't been able to ask my question because he objected before I was able to actually ask it.
Yes, please ask the question, Mr. Hunt.
You made that statement, right? Mr. Dahmer?
What was the question? Sorry.
You made a statement that when you were at Mount Zona, that you wanted to drink blood and have ketamine.
I don't remember.
You don't remember. So are you saying that's untrue or you don't remember?
I just don't remember. Could be true, could be not. Not sure.
Okay. And you also said, you didn't say, you actually did it. You bit and drank someone else's blood at Mount Zona. Do you recall doing that?
No, actually, I recall biting my own shoulder. That's it.
Biting your own shoulder for the blood?
Yeah.
Okay, so you did want to drink your own blood.
True.
And why did you want to drink your own blood?
You know.
Objection, Your Honor. Inflammatory.
Judge.
I'll allow it. Continue, Mr. Hunt.
Why did you want to drink the blood?
I don't know, man. Sometimes you gotta drink some blood, get some nutrition in you. You feel me?
Okay, so it's fair to say you find it enjoyable, like it gives you nutrition.
Sure.
Objection, Your Honor.
Okay.
Speculation.
Your Honor, how could he speculate as to what he likes?
He's guessing an answer, not on. There's no evidence that says he likes it or not.
Yeah, he just that's why he's testifying to it,
Well,
Judge.
I was objecting to it, but go ahead.
Please proceed. Yeah, proceed.
So tell me a little bit about this philosophy behind drinking blood. Why you enjoy it so much?
Well, you know, when I was like a kid, man, like from when I was born, basically, till I was like 18, I was locked in a closet with only a pack of saltines and a bottle of water every couple of weeks. So, you know, my dad used to come in and beat me till my bruises bled. So me and my sister drank each other's blood for nutrition. And we've just kept with it, you feel me?
Okay, so this has been like a family tradition, I guess you could say. Oh, it's just you.
Family tradition.
Objection, Your Honor. Misleading.
Sorry, I was trying to clarify, Judge.
Please clarify.
Sorry, what did you mean, sir? I didn't understand.
What do you not understand?
So was it just you that drank the blood, or was it everybody in your family?
No, me and my sister, man, we were locked in a closet, man.
Okay. And have you drank other people's blood before?
Yeah, probably. Most likely.
And why do you drink other people's blood?
You know, I'm not sure. Just sometimes it sounds nice.
I'm sorry, you said sounds, smells? I didn't hear the word.
Sounds nice.
Oh, it sounds nice when you drink blood.
Well, not specifically the sound, you know. More just saying, like, you know, every once in a while, crave some blood. But I haven't done that in a while, man.
When you say a while, how long's a while?
You know, actually, probably in Parsons. You know what you were talking about. Probably
Parsons?
the last time. Yeah.
All right. Okay, so when you were at the graveyard with Miss Killmer, and then you got out the car.
Objection, Your Honor. Hearsay. I'm not. I'm sorry. I'm sorry. Assumption.
Yeah, I don't know what you're talking about, man.
Sidebar, Your Honor.
Yes.
Mr. Hunt. Mr. Hunt continues to prosecute and essentially judge my clients guilty over and over again in the lines of questioning. He's done it with Ms.
Trying
Killmer.
to impeach the witness.
You cannot. It's not your responsibility to deem my clients guilty or not guilty. It's the courts. You continue your line of questioning. You continue to reference. You've done it time and time again. You've been warned once already.
I'm curious as to what you mean by he's asking questions, deeming him guilty.
He's continued
asking
to.
specific
You
questions.
said He said you drank when you drank blood or on the scene or whatever. He continues to reference it like it was factual. Everything is alleged. He's already been one once, Your Honor, in questioning the other
I
witness.
mean, but it was testified about previously, so.
Yeah, that he's drank blood in the past. He's already testified that he wasn't on the scene. You can't continue to accuse the individual.
He's lying.
That's the court. That's for the court to decide. I mean,
I'm not lying, bitch.
Okay, but it's already been decided that he was on scene.
Judge, with all due respect,
who's decided that he's been on scene?
To Mr. Johnson. You.
That's not your responsibility. That's why we're here.
Oh my lord! You told me not to ask Miss Killmer, and you said.
Just be advised that we can hear you over in the corner.
Okay. You said not to ask Miss Killmer, and then you went on to state if Mr. Dahmer testifies, that's a different story.
Please keep the line of questions specific to the docket and the evidence that has been presented. If you'd like to ask him directly, if he was on the scene, etc., go for it. But I would agree that you are alluding to the events rather than asking direct questions.
He's not even alluding. He's affirming. He's telling him he was on the scene drinking blood. I mean, this is ridiculous. It is for the courts to decide whether the clients were there or not. We have not determined definitively whether the individual on the stand was there or not. He's testified that he wasn't, and you continue to assert that he
for
was.
the witness to testify to. It's for the witness to testify to what happened and therefore establish the facts of the case.
And he's already stated that he was not there, and you keep saying he was.
But we're trying to impeach him on that, is what we're saying. We're saying he's lying, so we're trying to impeach him on that fact.
I understand where you're coming from, Mr. Hunt. There are other ways to do that. Mr. Evans, I understand what the function of the court is. You do not need to keep reminding me.
No, I'm not
or the
reminding you,
other
Your Honor. I was reminding the prosecution. I know very well that you know what you're doing.
We know why we're here. Keep the questions direct and relating to the evidence that has been presented. You may ask the witness where he was, what he recalls, etc., etc. But to continue to allude would constitute a leading question.
I mean, Your Honor, respectfully, how many more times are we going to have this conversation with the prosecution?
Hopefully not. Are we clear on how to proceed?
Yes, sir.
Thank you.
Thank you.
Your Honor, can I speak to my lawyer real quick?
Sure. Go ahead.
What is it, Edward?
He keeps on doing this shit, man. It's really fucking pissing me off.
Yeah, that's why I just had the sidebar. He continues to do it. So if he does it one more time, I'll continue to object and have a sidebar.
Yeah.
All right. Let's proceed, Mr. Hunt.
Okay, so when you were found near a trash can, you had a knife on you and a pistol, and among many other things, right?
True.
Right. And you like drinking blood.
Asked and answered, Your Honor.
Sustained.
For clarification, do you like drinking blood?
Sometimes, man, I don't know.
So you had the knife, and you also like drinking blood. And your testimony is that you weren't there.
Yeah, I wasn't.
If I could have one moment, Judge. I could have one moment, Judge. And sorry, sir, one more question. How did you get to the trash can?
What do you mean?
How did you get to the trash can?
I walked there, man.
Walk there from where?
I don't know. Can't remember. Probably some place near there.
Near there?
Yeah.
Okay. And is the graveyard near there?
I guess. I don't know. I've never been to the graveyard before, man.
Objection, Your Honor. Inflammatory. We all know where
Do you even
Mr.
know what
Dahmer's from.
inflammatory means? Like the definition of it?
Yeah, it's intended to cause prejudice. Okay,
because
we
that is
know where the fucking cemetery is relative to the fucking alley.
All right. Order in the court.
It's a prejudicial question. He knows where the cemetery is relative to the alley.
Judge, I'm asking questions relevant to the case. We had a discussion in sidebar, and he said he walked over there from somewhere nearby, and I'm making the point that the graveyard is nearby.
Yes.
Okay.
Proceed.
So the graveyard is nearby, right?
I guess so.
And you walked from nearby, right?
Sure.
And you had a knife on you, right?
True.
You like drinking blood, don't you?
Asked and answered, Your Honor.
I have no further questions, Judge. Thank you.
Thank you, Mr. Hunt.
Thank you, Your Honor. Edward, were you at the cemetery?
No.
We'd object. That's and answered. We move to strike.
Clarification, Your Honor. Edward, to clarify, were you at the cemetery?
Leading.
We'd object as the leading judge. We move to strike.
It's a yes/no question, Your Honor.
Exactly. That's illegal.
Yeah, that study the definition of leading.
Edward. One second, Your Honor.
Mm-hmm.
Edward, where were you? Where were you when you were found?
Asked and answered, Your Honor.
Clarification, Your Honor.
Okay.
Where were you when you were found?
I was in an alley, man, taking a nap.
And for clarification, Edward, you were not at the cemetery.
No, I was taking a nap, man, sleeping.
No further questions, Your Honor.
Thank you.
Wait, sorry, Judge. One more question. Sorry, so you actually have a couple things on the line, don't you?
What do you mean?
If you're convicted here today, you're going to go to prison. Right?
Sure.
And you don't want to go to prison, do you?
No.
Relevancy,
No one
Your
wants.
Honor.
I assume you're getting to the point, Mr. Hunt.
Yes, sir. No one wants to go to prison, right?
Sure. I mean, maybe some people do, man. I don't know.
You do a lot to avoid going to prison, wouldn't you?
Speculation, Your Honor.
Yeah, what you trying to say, man?
All right. So you do a lot to not go to prison, wouldn't you?
I just live a normal life, man. I don't know what you're trying to get at.
Right. So what's the answer to my question? You would do a lot to get away from prison, right? You do all that you could so that you don't have to go to prison, correct?
Sure. Hired a lawyer to beat
I have no
your
further
ass.
questions, Judge.
Thank you. Mr. Dahmer, you may be seated. Please remember you're still under oath.
Thank you.
Mr. Evans, do you have another witness?
I did subpoena the alleged victim, Your Honor. Just wanted to make sure the record state that the victim was not responsive to any contact, and the subpoena obviously should be held in contempt of the court.
So noted.
Nothing further, Your Honor.
Judge, may we approach?
Yes.
You able to hear us? Judge?
Yes. Can you not hear me?
You're down here. Ha! No, you're up there. Okay. I have Deputy Jacob House here. I don't know if you'd like him to testify, but he can testify as to the drinking blood statements.
He wasn't on the original witness list, Your Honor.
It'd be a rebuttal, Judge.
The I think the rebuttal evidence is enough.
Okay. So you
It
don't.
has been
it's-
referred to. No.
Okay, we don't need to hear from him. I don't mind. I just want to make sure.
Yeah. What are your thoughts, Mr. Evans?
I mean, I would have had a chance to depose the witness. This is why we have to enter witnesses into the docket in advance, Your Honor.
I would say
It
that
would
the
be, it would be rebuttal evidence.
I
So it
understand.
doesn't. Okay. I don't care to call him. I'm letting you know if the court would like to hear from him.
Yeah, I understand. The rebuttal evidence of the previous police report and Parsons has been entered, and I think that the witness would be redundant.
Okay, sounds good. All right, thanks, Judge.
Okay, is that it?
Yeah, yeah.
Mr. Evans, are you resting your case?
The defense rests, Your Honor.
Okay. At this time, I'm going to call a brief 5-minute recess for both counsels to collect their thoughts for a closing argument. We will reconvene at 11:50. That was a statement, not a question. We will reconvene at 11:50. Thank you, Robertson.
Yeah, man, that lawyer's got me mad.
It's all right.
Oh, gee.
Let me get to Worcester. It's all right.
Do you need
So, like I said, at the end of the day, there's no physical evidence. It's going to be Thompson's testimony against yours.
Yeah, he kind of made himself look really bad.
He did.
Well, the lawyer did. Unfortunately, Kitty, I asked you if you've ever been arrested before and how long you've been in the city. So,
Kitty did not remember any of that.
yeah, that's gonna be problematic because they might hit you with a perjury charge as well. Yeah, I can't do anything about that. This is why I always tell you guys to tell me the truth, so that
Oh, that's
we don't.
okay. Kitty honestly didn't remember.
That's right. It's right. It's water under the bridge at this point. Just be aware that that perjury charge can be filed against you as well. But again,
They probably forgot about it. They're not too smart.
it's gonna be everything at this point is circumstantial. It's their word against yours. The evidence there's no physical evidence that ties you directly to the blood, other than the drinking. And we've already testified that that Edward wasn't there and that Kitty, the alleged victim, was complicit. If he had been here, he would have perjured himself if he said that he was not complicit. As far as I'm looking up in the statutes that states whether or not you need a license to draw and drink blood.
Yeah, that's a pretty weird question, man. If someone was trying to do that, why would they give a fuck if they had a license or not?
Yeah, I need to.
Yeah, it always tells me the truth, so I was.
I need to verify that. This
Okay,
is why
here
we
you
have
ask them,
paralegals. Give me 1 second.
Hell yeah.
Alrighty.
Hey, can you do me a favor real quick? I can't find anything in the statutes that states that you need a license to drink blood or draw blood for that matter. Can somebody just look in the criminal code real quick and do a quick search?
Okay.
I know you have to be medical. You can't be impersonating a doctor, but they weren't doing anything medical. They were just drawing.
Hey, you're not whispering, just so you know.
They weren't drawing blood. They were drinking it. You don't have to draw blood to drink it.
Okay. I'm just looking real quick.
I need to go to the use restroom in my head.
Okay. Do you want to help me out, Marcus? Are you looking as well? Okay. I'm looking at the general. I'm not the criminal.
Excuse you?
Okay. It might be something under torture mutilation. I'm not sure.
I'm looking at general laws and definitions, but I'll move on to, and I don't, Marcus, I'm not sure what he's looking at. Let me have a look. Torture mutilation. The intentional harming of another individual with the intent to inflict pain and discomfort, remove body parts, and leads to permanent damage of the body. Organ harvesting, the taking of organs or other body appendages of another person by force or intimidation.
There's nothing about drinking, requiring a license to drink someone's blood.
Negative.
No, but maybe be careful with that because there was the removal of a limb, right?
Yeah.
Don't want to walk into something.
Hey, Evans.
Yeah, what's up, Marcus?
Man, listen, I know you're really pumped out to this case, and I saw you're fighting teeth and nail, but I'm not going. You know, I never lie, man. This trial doesn't look good for your clients, because you know it doesn't look good. Like he had.
Oh, trust me, yeah, I'm
prior
aware.
conviction.
It was not my decision to put them on the stand. I advised them to plead the fifth. They wanted to take the stand. They're in court. Ultimately, we have to do what the clients ask for, right?
Yeah, that is correct.
You know me, I explicitly tell my clients in the cells to tell me the whole unadulterated truth. I asked Miss Killmer how long she'd been in the city and if she'd ever been arrested, and she told me straight up to my face that she had never been arrested. So that was a surprise, and this is why it's important to make it clear to our clients in the cells wherever we meet them, that they need to tell us the whole truth, so that we can give them the best defense. But yeah, I did advise them to plead the fifth, and not having the fucking alleged victim submit to the subpoena was also a problem, because he would have testified that he was complicit in the blood drinking, and that really no crime was committed.
Right, you can use that in your closing
All right,
statement.
guys, now back in session.
All right, good luck, man.
Thanks.
Good luck, Joe. You got this, man.
Welcome back. At this point in the proceeding, we are going to move to closing arguments. Prosecution, begin.
Sorry about that, Judge. May I please the court, counsel? Ladies and gentlemen.
Mr. Turner, if you're
So,
speaking, I can't hear you. Oh, sorry.
I want to talk about the evidence that we've heard, and then we'll talk a little bit about the theory of the defense, and then we'll try and close it up, because I think we can all agree that we've been here for too long. So I'll do my best not to keep you here for much longer. The first witness that you heard from today is Alex Johnson. Alex Johnson saw the defendants taking the victim, Ice Williams, out of the car, and when he walked up to them, they were talking about tasting each other's blood. Now, you heard Mr. Johnson testify. He testified to all of that. He testified that he saw a male and a female. He testified that he could positively identify Miss Killmer, and he testified that they were tasting blood. The next witness you heard from was the sergeant, Sergeant Nicholas Thompson. And Sergeant Nicholas Thompson testified to multiple things, so I'll try and break it down as good and also as fast as I can. Nicholas Thompson arrived on the scene. When he arrived on the scene, he saw the two defendants at the car talking with the victim. He saw everything that was happening. He saw the pinky finger. He saw the blood coming out of the wrist. He saw everything happening. At one point, Sergeant Thompson, he separated the defendants from the victim. Now, when he separated the defendants, he talked with the two defendants, Edward Dahmer and Kitty Killmer. See, when he talked to them, he talked to Mr. Dahmer, and he said, "Hey, Eddie." And Mr. Dahmer replied. He saw the paint around Mr. Dahmer's eyes. You could see it when he was testifying. He has black paint around his eyes. It's not hard to see. And the sergeant, he testified that he saw that. He saw his hair. He saw his hair coming out of the helmet. And then he saw it again when Mr. Dahmer took off the helmet. The evidence you've heard. You heard Alex Johnson testify that Miss Killmer was positively identified, but I don't think there's a dispute with Miss Killmer. Miss Killmer was there. She was arrested on the scene. She admitted to everything that she did. There's no dispute about that. So let's talk about Mr. Dahmer. Mr. Dahmer was identified by Sergeant Thompson. Well, you might ask how. How could somebody identify somebody based off their hair, off their voice, off their skin paint? Well, it's quite simple, really, because when we heard the testimony, you heard that Sergeant Thompson knows the defendant quite well. Sergeant Thompson has been to therapy sessions with the defendant. This is nobody new to him. This is not some odd call. This is not some first-time appearance. The defendant has been to a therapy session with Sergeant Thompson. I mean, there is no dispute that Sergeant Thompson positively identified the defendant. I mean, where is the dispute? You heard the officer testify to the hair. And the defense talked a little about how people having orange hair. What they left out is his kind of hair. If you recall, I asked, have you ever seen somebody with orange hair and his kind of hair? He said no. And the defense asked, have you ever seen anybody with orange hair? What the defense did is they're trying to leave out the crucial parts of the testimony. Mr. Thompson testified that he's never seen somebody with Mr. Dahmer's kind of hair. And what's that kind of hair? It's hair. It's slicked back. It's coming down his neck, and the sides are cut off. Sergeant Thompson's never seen that before, and that's one of the reasons why he identified Mr. Dahmer. I mean, that's why he pursued Miss Killmer. He saw the defendant. He knew who he was. There was no doubt in his mind that Mr. Dahmer was on that scene. No dispute. So let's talk about the evidence that you heard from him. He came up on the stand right here and he said that he wasn't there. He was essentially conveniently in the area for no reason at all. He mentioned cockatoos, and then on cross-examination he said, well, actually I was going to cockatoos later. I wasn't actually going while I was down there. That was just something I was going later in the day. So let's talk about the testimony that you heard from Mr. Dahmer. Mr. Dahmer testified that he likes to drink blood.
Didn't you say you had already been to cockatoos, or did you
Mr.
say you're going
Dahmer
later?
testified that he was near the scene, but there's no dispute about that. He was arrested on the scene.
Did
When
you
he
say
was
you were going later?
arrested, they
You
found the
didn't say you were going
knife.
later, though.
They found the
Oh,
knife that
whatever.
was used
That's
to
right.
cut the victim's pinky finger. Mr. Dahmer testified to his, what I would say, obsession about drinking blood. And I think that comes into play because you heard Miss Killmer testify. She said, I didn't have the idea of drinking the victim's blood. No, it was the other man. It was Mr. Dahmer. Mr. Dahmer had the idea of drinking blood. So what is Mr. Dahmer's experience? Is this something he does commonly? Well, yeah, that's what you heard. Mr. Dahmer was 5150'd and he was out Mount Zona. And the evidence that you saw from the police report is, and I quote, Edward bit and drank someone else's blood at the facility. He bit and drank someone else's blood at the facility. What Mr. Dahmer is asking you to believe is so far-fetched from what actually happened. He was seen at the scene. He was identified by Sergeant Thompson. He likes to drink blood. Oh, but the other person, he was the one who said, let's go drink the victim's blood. Everything falls in line. Everything. There is no dispute that Miss Killmer and Mr. Dahmer, they kidnapped the victim, Ice Williams, and then they cut his pinky off. And then they cut his wrist. And they decided to taste each other's blood. And it all makes sense because Mr. Dahmer likes doing this. I mean, that's what you heard. He likes to drink blood. It all makes sense. That was what he wanted to do, and that is what he told Miss Killmer to do. The fact is you've heard all the evidence. You've heard Alex Johnson testify. You've seen the reports from the scene, and you've heard Sergeant Nicholas Thompson testify. You heard the two defendants testify, and the one defendant admitted to everything, and the other defendant admitted to like drinking blood. And as you heard from Miss Killmer, well, that's what the other person wanted to do. Your Honor, when you return with the verdict, we ask you find the defendants guilty on the count of assault. And the reason why we ask that is because on October the 30th, the two defendants, Miss Killmer, they got out of the car and they took the victim out the car, Ace Williams. And when they took him out the car, they held a bat out and they were holding the bat. And while they were holding the bat, this gentleman, the victim, he had his pinky cut off and he had his wrist slit. So if we look at the law, if we want to reflect on the law for assault, you heard Sergeant Nicholas Thompson testify to this. A threat of bodily harm coupled with an apparent present ability to cause the harm. So what is the threat? The threat is having the bat. This man had his pinky cut off. He had his wrist slit. There was a threat. And she had the ability with Mr. Dahmer to cause the harm. She had the ability to hit him with the bat. Mr. Dahmer could as well. We ask that you find the defendants guilty on one count of kidnapping. You heard all the witnesses testify. the witnesses testified that, hey, he got out the trunk when both of them got out the passenger seats, the driver and the passenger seat, and the victim got out the trunk, and he was not there willingly at all. I think that's very apparent through the testimony. You heard Alex Johnson testify to the fact that the victim said he wasn't there willingly. He didn't get in the car. He didn't want to be there. He certainly didn't want to have his pinky cut off. We ask that you find the defendant guilty on 1 count of torture and mutilation. And we ask that because the defendants cut the victim's pinky and they slit his wrist. And when they did that with Mr. Dahmer's knife, the knife that was found on him when he was arrested. And they both partook in this incident. This was no one-person crime. They both were there, they both participated, they both saw it happen, and none of them did anything to stop it. We ask that you find the defendants guilty on 1 count of fleeing and eluding. And the reason why is because when Mr. Thompson, Sergeant Thompson, he separated the victim, they ran. They ran away. They bolted. They didn't want to have to do anything with law enforcement. They wanted to avoid being arrested. And finally, we ask that you find Mr. Dahmer guilty on 1 count of unlawful possession of a Class 1 firearm. And through the evidence you've heard, it's been made very apparent, it's been proved that he had a firearm on him when he was arrested. So we talked a little bit about it at the start, about all the evidence. It's all been heard now. You've heard all the evidence. You've seen all the witnesses. We know that the state has proved its case beyond a reasonable doubt. There is no doubt that the defendants committed these crimes. None. They did it. They did it with malicious intent. And then they came here and lied. It's unacceptable. And we ask that you hold them accountable. We ask that you find them guilty on all counts. Thank you, Your Honor.
Thank you, Mr. Hunt. Mr. Evans.
Thank you, Your Honor. So the state made a lot of statements. Burden of proof, reasonable doubt. These are things that were never actually confirmed in this case. For as much as the prosecution would like to state that there's no doubt that my clients were guilty of the crimes being charged, the fact of the matter is there's no physical evidence. There's no forensic evidence, conveniently. The other arresting officer was not available. The alleged victim did not comply to the subpoena. All we have is the testimony of 2 eyewitnesses who one was 150 meters away, and Sergeant Thompson, and yet we still have no physical evidence that ties specifically Mr. Dahmer to the scene. And Ms. Killmer has no reason to testify in the defense of Mr. Dahmer. She's never met him. It doesn't do her, it helps her out in no way whatsoever. She testified that she could not identify or see the individual on site. The prosecution would have you continually try to convince you that Mr. Dahmer was on site, but again, there's no physical evidence that ties Mr. Dahmer to the scene. And Ms. Killmer has already testified as well that the victim was complicit in the act. She didn't have a knife on her. She didn't cut the finger off. She didn't do any of this. She simply drank someone's blood. If we're convicting people on our hobbies or our kinks, whatever you want to call it, then I'm sure a lot of us in this state could be remanded to Bolingbroke for a variety of reasons. The fact of the matter is there was no crime committed because the alleged victim was complicit. We heard testimony that Mr. Dahmer could be identified by Sergeant Thompson based on voice and recognition, all these other things. But those of you that ever ridden a motorcycle in the city know that motorcycle helmets are pretty damn dark. I have a motorcycle helmet myself. I can barely see my face in the mirror. I really can, actually. So to state that Ms. Killmer, who was standing next to the individual in question and could not identify him, and to say that Mr. Thompson could is interesting. I think we look at the physical evidence again. There is none. There's nothing tying, specifically Mr. Dahmer to the site, and we've already spoken about Ms. Killmer. I think we need to be careful as a state when we begin to prosecute alleged criminals or alleged suspects based on solely the testimony of certain individuals. And again, the burden of proof was on the state to prove beyond a reasonable doubt that these individuals were guilty of crimes, but with lack of physical evidence, I find that hard to believe. We don't prosecute individuals on our past, right? Sure, they want to tell you that there was an MO to be established, but that still doesn't prove someone did something just based purely on their past. We all have done things in our past, and I'm sure none of us have done in our future. And so to convict someone simply on their past transgressions or their past activities, I think would be inappropriate in the lack of any kind of physical or forensic evidence. So, with that being said, the prosecution has not proven beyond a reasonable doubt, in my opinion. They've provided a lot of circumstantial evidence, a lot of hearsay and conjecture. And with that being said, I hope this court finds my client's not guilty. That's it, Your Honor.
Thank you, Mr. Evans. With the conclusion of the closing statements, I will recess for the next 5 minutes. This court will reconvene at 12:11 a.m. Eastern Time. Before we recess, may I see both sides, brief sidebar up here. So,
Oh shit.
clarification.
Athletic.
According to the charges on the docket, the assault is aggravated. According to the charges, the original charges, because there was a clerical error originally with the assertion that the possession of a illegal class 4 firearm applied to both defendants. Originally, Miss Killmer was not charged with assault. Originally, Mr. Dahmer was not charged with aggravated assault. Is it the assertion of the prosecution that the charges as written on the docket are what is being put forward without the possession of an illegal class 1 firearm for Miss Killmer?
Well, it's not. We're not charging with aggravated assault. If that's your question. Sorry, I might have missed your question.
That was the question. It does say aggravated assault on the docket, which is why I'm clarifying this.
Are you talking about the original separate dockets?
Oh, the original. Oh, I've never seen the original docket, so I couldn't tell you.
Oh, I see.
But yeah, to my understanding, we're just charging with assault, kidnapping, torture, mutilation, fleeing, and eluding, and then for Mr. Dahmer, unlawful possession of class 1.
Okay, that was it.
All right.
All right, I'll see you back in 5 minutes.
Okay.
Kitty will be in her head for a second.
Yeah, man, I'm still not understanding how they're using seeing through a fucking biking helmet as evidence.
Yeah,
We all know that's not possible.
I know. They're alluding that you guys are lying on the stand. I'm alluding that Sergeant Thompson lied on the stand. But again, unfortunately, in this state, law enforcement officers, the testimonies and word carries a lot more weight than everyday citizens, which is bullshit. I mean, in this situation, I would have brought a fucking helmet into the courtroom and worn it on my head, and asked the judge to fucking look at my face. But, you know, it's bullshit.
That's what I'm saying, man. Like, we've all worn biker helmets before. You know you can't see shit through that, let alone people see into it. Like, what are you talking about?
Yeah, honestly, like I said the entire time, your case was paper thin. Sergeant Thompson basically lied on the stand, in my opinion, with regards to being identified through the face mask, and the fact that he, quote unquote, remembered notes a month after, but he couldn't remember the day of is bullshit. It's an unfair system, unfortunately.
Yeah, it really is, man.
In Kenny's situation, what fucked us was, you know, the alleged victim is no longer in the city, I guess.
Oh.
I mean, I don't know if his passport got revoked. I just don't think he lives here anymore. And you know, she got screwed by basically having not done any of those things, cutting the hands, whatever. So she shouldn't be charged with torture and mutilation.
True. You know what's the crazy part?
Yeah.
That dude cut us too.
Yeah. So
I gave him a knife and he cut my wrist so he could
Yeah,
drink my
he
blood.
was like super excited about it. He wanted to do it.
yeah, like I said, I'm gonna appeal. I'm gonna appeal after the fact, regardless of the. Well, we'll see. We'll see how the outcome goes, but we're gonna appeal the lack of proper filing of evidence from the first witness's notes. And if you're found guilty, we'll appeal the decision based on lack of evidence and just go through that procedure.
Wouldn't his past records be like other evidence thingy too?
Whose past records? The
This
MDT.
guy.
Yeah, MDT. The police records are I think a matter of fact.
Cool. Yeah, Kitty
So-
doesn't know anything about the law.
No, I'm honestly the evidence that's submitted or evidence that's used by the witnesses has to be submitted as a.
Hey, sorry to interrupt. Can I speak with you quickly?
Yeah, what's going on?
Oh no, I was just gonna say good job.
No, I appreciate it. Honestly,
Even though it got heated, I don't know.
yeah, no,
Get
there
used to it though. This is what it's like 24/7. This is your first case, right?
Yeah, this is my first trial case.
It's like this all the time.
Yeah.
Get used to it.
No, I mean honestly, the between you and me, I told my clients not to take the stand. They wanted their day in court.
Yeah, that was.
And so this is, you know, the whole Killmer situation was just I almost fell over on my fucking where I was standing. I explicitly asked her how long she'd been in the city and if she had a record, et cetera, and she just straight up told me that she. So
Hey, good luck anyways. You did good.
No, I appreciate it.
I don't know where it's gonna go, so good luck.
No, I appreciate that. No, I mean I hope you and Oliver obviously understand that there's no hard feelings.
No, of course.
it's a bit
Trust
of a
me,
show.
I was on your side just a week ago doing the same thing to them. So.
It's a bit of a show sometimes.
Oh,
you know, it's
100%.
theater. So Oliver, good job to you as well.
All right, but hey, we'll hear the verdict. But yeah, good luck.
Yeah, you too. She's gonna ask you to stand while she reads the judgment.
Okay.
Okay.
You're right. You get this thing done.
All right, the court is now back in session.
You may be seated. I have deliberated after hearing the arguments and testimony, as well as the closing arguments from both prosecution and defense. This court has made the following conclusions regarding the charges. Regarding the defendant, Kitty Killmer, this court finds the defendant on one count of fleeing and eluding, guilty. One count of torture and mutilation, guilty. One count kidnapping, guilty. One count assault, guilty. Regarding the defendant, Edward Dahmer, this court finds the defendant on one count fleeing and eluding, guilty. One count assault, guilty. One count torture and mutilation, guilty. One count kidnapping, guilty. One count unlawful possession of a Class 1 firearm, guilty. Additionally, this court finds Ice Williams guilty of misdemeanor contempt of court. Does the prosecution have
Sorry.
a record? Sorry?
Could you repeat your last statement about contempt? I missed.
This court finds the Ice Williams guilty of misdemeanor contempt of court. The fine for which will be $500. Does the prosecution have a recommended sentence for the defendants?
Judge, we'd ask that the defendants be remanded back into the care of the state, remanded to Bolingbrook Penitentiary, and serve a sentence of 200 months with credit for time served.
Thank you. Mr. Evans, do you have a counter? Mr. Evans?
I'm sorry. I said no, Your Honor.
Okay. This court would agree with the assertion of 200 months for 200 months with credit for time served. The fine for Ms. Killmer will be $1,450. The fine for Mr. Dahmer will be $2,000. And let the record show the fine for Mr. Williams' misdemeanor contempt of court is $500. So ordered.
Thank you, Judge.
Wow, just
That
wow.
didn't sound super good.
No, you got found guilty on all counts, which is bullshit.
Yeah,
like I said,
that's
we'll
kind of crazy, right?
like I said, we'll appeal.
No problem.
We'll appeal based on the stuff that we discussed. The thing I need to find out is about your bail, because you did pay a bail, and that should be counted into your fines, I believe, or returned to you. So I'll inquire about that. If you have any questions while you're in Bolingbrook, please let me know. Like I said, I'm going to appeal the decision in appellate court, and we'll go from there.
Alrighty. Oh yeah.
But I'm sorry. I'm sorry we didn't get the decision that we wanted. You guys did great.
Yeah, too bad they fucking lied for all their evidence.
Yeah, like I said, in this state, basically what it came down to is the police officer's testimony, and him saying that he could see your hair and all that shit is complete bullshit. So
The fact that this case wasn't dismissed based off, I'm assuming you made the motion.
I
for
did.
The fucking,
I did.
That's ridiculous.
Yeah, the judge said that I had to have objected.
No, you did not.
Yeah, yeah.
Oh
So
my God,
we'll file
bro.
an appeal. We'll file an appeal.
That's so fucked.
Okay, so
And if so, just so you guys know, if we file an appeal and we win that appeal, you'll be financially compensated for your time, and for the misjudgment. So
Damn, I'm gonna need like a fucking $100,000, man. I've been waiting over a month for this court case. Bullshit.
we're not done yet. So we'll file the appeal and we'll keep fighting.
Yeah, you're the best, smartest, super duper famous. You get him.
Like I said, I'm sorry we couldn't get the judgment that we wanted, but we're gonna keep fighting. So
That's okay. It's totally fine. It's just so weird. Kitty didn't do anything with knives, and then she still got that.
yeah, there was a
Crazy how they're saying they could see through a fucking bike helmet from like 30 meters away and see my features, which we all know is impossible.
They convicted you on circumstantial evidence and your history, which is complete horseshit. That sets a bad precedent for the entire state with regards to basically prosecuting people on their past without physical evidence. I mean, to state that they found a knife but had no forensic evidence, I don't even know how that's allowed.
That's what I'm saying, man.
It's lazy police work. They didn't send it to forensics.
Yeah,
Like, it's lazy.
And for the record, I'm
Why
also
are we
gonna
rewarding lazy police work?
I might
This
file
is
I might file a complaint with the BCSO regarding the fact that Sergeant Thompson didn't essentially fill out a complete police report at the time of the arrest and decided to remember a month later details of a case.
Reckon Thompson,
So-
I'm not even capable of doing anything right now.
So-
yeah. In my head, it feels like 6 a.m.
You all
Yeah.
tried your best, so you know.
I appreciate that, Marcus.
Yeah.
I've probably charged him like twice on everything, so,
So-
I
At the
end
end
up
of the
with
day,
400 months.
Oh wait, hold on. Hey, police, sir, Mr. Police Officer, sir, can you come over here?
Well,
Hey, it's Maxwell. No, it's not Maxwell.
no.
Sorry.
Hello,
Can you-
Mr.
can you-
Dahmer. Long time no speak.
Can you put your helmet on real quick for me, again, and lower
Why?
the visor?
Okay.
Yeah, I mean, it's amazing. It's amazing how much of your face details I can see. It's astonishing.
Okay.
It's astonishing.
It depends on what visor you wear, sir.
There's only two visors for that helmet, sir. There's a mirrored visor and a matte black visor.
Okay. Is this a social experiment or something like this?
No,
I
just
don't know.
the judgment's been made, officer. I just wanted to clarify, to validate
Mr.
our
Dahmer, do you need
statements.
some shoes?
No,
I thought last time we met, you at least had shoes on.
Fuck fuck shoes.
You hate shoes.
Yeah. Can't trust your eyes, man.
I
Gotta
think
feel where you're walking,
I
bitch.
think
Hey, how's
Damn,
Barry
just
going?
saying. I don't
Is
know,
Barry still your
man.
dad?
Yeah, of course.
Yeah, yeah.
when I
You still
appeal
trying to
this,
look
I'm
for your
bringing a
mum?
fucking motorcycle helmet to court, and I'm gonna put it on in front of
Yeah.
everybody and ask them to please look through my
Right.
fucking helmet.
You should have the judge look at this man's fucking helmet, man. I'm telling you, it's like, wow, so much detail.
Yeah, exactly. That's why when he said he could make out your face and I was like, are you fucking kidding me? Have you never worn a fucking bike helmet? Like,
Right?
it's
That's
ridiculous.
what I'm saying.
So, anyway, we'll deal with it with the post. I swear, I'm not even kidding. We're gonna appeal this, and I'm gonna fucking walk into court with a fucking motorcycle helmet on.
Yeah.
Just shout Mark or Dre.
No, we would never.
Fuck it. Let them know, bitch. What's good?
No, it's all right. It's all right. I'm just still a little tilted.
Yeah,
me too.
that's kind of annoying.
All right, I'm gonna take you both into custody now. Okay.
Oh no, please.
Edward,
Sorry.
Kitty, if you need anything from Bolingbroke, please let me know. Like I said, we'll file the appeal and we'll go from there.
Okay.
Yep. All right, I need you to both turn around.
Hmm.
Eddie, I need you to turn around. Thank you.
You know what I realized? DOJ has access to MDT and we don't.
Oh yeah, that's
There's reasons.
That's
though.
bullshit.
No,
Can
there's
you please
reasons.
put your mask back
Yeah,
on?
but they can have access to all the information like that. You must go like
Can you
in
put it
the
on? Thank you.
freedom
There's
of information.
No, there's info.
Alright,
Yeah,
Eddie,
well,
do you
we
have
can
anything on you
always
that's gonna poke stickers
request
at
that,
me?
but there's information on the
Thank you so
MDT that we
much.
are not or shouldn't be
That
privy
feels
to
better.
apparently.
All right, I'm just gonna make sure.
All right.
If I don't get my bull cue back, I'm fucking suing, man.
No,
I'm just saying.
I've
shouldn't.
asked.
Yeah, but all right. So it's you know, they have an advantage. You have to consider that. We'll talk at the meeting. It's fine.
Do you have anything on you, Kitty?
Nope.
Here's a phone, radio.
Free
a
me
toy.
for real.
Yeah. Just a joint on her if you want to take that off her, but other than that.
What's illegal about one
I better
joint?
get my goddamn
Oh
bull
wait, going to
cue,
prison.
man.
Maybe not
Fuck
allowed.
you.
It's not like weed is available in prison, right?
Pretty much.
How you doing, Dre?
I'm doing right. Just trying to take out my twitchy contact lenses and give them to somebody else.
Right.
Yeah. Let's go outside. We can do this outside. I'm fucking. I need a
Over this
drink
way.
and a punching bag.
Mm-hmm. I have to go to a meeting and for IA.
Oh my god, you need to call Lex and be like, yeah, everything
Okay.
Schumann said was...
Yeah, well, and
Hold on. I've got all my stuff in your car, Kayla.
we'll go over to grab that.
Okay.
So we do a meeting today? No, all right.
It's a tough break. Just, I'm with you. Some hearsay testimonials just doesn't do it for me.
Yeah, I mean, I don't know how we can, like, if we're gonna continue fight these cases and it's all based on police officers' testimony versus the clients, the suspects, I don't even know how you fight that.
Wow.
And they had no physical evidence.
I mean, even talking about the hair, fucking judge had the same hair, like 2 feet away.
Yeah.
All right. There is one small thing. So
what's that?
They did lie in court, so that like gives them minus points. Either intentionally or not. Like both of them lied on stand.
Well, yeah, I mean, honestly, we're lucky they didn't get perjury too. But hold on, I gotta do something in my head. 1 second, sorry.
Yeah, no worries.
Yeah, no. Right. So what I was saying is like Kayla, right? There's not an even playing field, right? Because DOJ has access to all the stuff and toys and everything else, and we're kind of playing catch up.
And apparently, private attorneys such as private attorneys have more resources, time, and money than we do. So usually, bigger cases go to private attorneys because they can equal the Department of Justice, and we don't. It's
We
just
should.
a standard that it's honestly 9 times out of 10 cases they'll roll up. At one point, I've seen 4 of them on their desk, and 1 public defender or 1 private lawyer. It's ridiculous, but you know.
Yeah. So, yeah, we need to strategize about how we're going to handle the situations where literally the only testimony is the officers, and they can just straight up lie. I don't even know. This is the things that we need to talk about with the state representatives, because with a lack of physical evidence, for us to rely solely on the testimony of an officer is just criminal, literally.
Did he not lie too? Didn't he say he responded to a call of a 911 call of a kidnapping? But didn't Mr. Johnson testify that he didn't report the kidnapping in his 911 call? Like, it just sounds like it was colluded after the fact that it was kidnapping.
Wouldn't surprise me, maybe.
Right? Like they talked to Mr. Johnson and said, "Oh yeah, kidnapping."